property might be mortgage in the bank.
Your Lordship,
So
it is a sole owned property, Your Lordship.
maybe you might be guarantor or a surety of the your
Not
husband.
entered into any kind of.
Yes, what is the
Lordship was kind enough to my lord, this particular matter, terminal benefit related matter, my lord. Since 2021 it is pending. Exchange of evidence, everything is done. It is appearing in the list 558. Possible Lordship, kindly, my lord.
Lordship,
My lord, for the inclusion of a hearing, any specific date.
17th February. Urgent motion.
Lordship,
Urgent motion.
But inclusion of a hearing, it predicts a complete matter of 2025 or predicts a complete illegally terminated by an authority.
Who is for the other side?
Sir, we have served notice. Upon notice have mentioned.
इसको ना 2 बजे का कौन सा डेट खाली है देखो.
Lordship, may
2 बजे का डेट खाली. बाईस 23 24 25th February at 2 p.m. as a specially fixed matter. From the other side.
Lordship, may I permitted to mention item number 278 running the today's list for upgradation, Lordship. The ground of urgency is the Lordship. The petitioner is in custody for more than 21 years and he is undergoing severe health issues, Lordship.
Huh?
He is undergoing several health issues, Lordship, and he is in custody for more than 21 years.
What is the conviction?
Sir, seizure too, Lordship.
So, how you can get the permission here? Your case has not been considered. Oh, 24th February.
I'm grateful, Lordship.
My lord, may I be allowed to mention a matter? My lord, the matter is running as item number 95. It's an electricity matter, my lord. My lord, kindly
95.
Yes, my lord.
What is the name?
It releases the matter. It's a
What is the name?
Devabrata Sarkar and another versus State of West Bengal and others.
Though the matter is listed as item number 95, but the learned counsel for the petition has mentioned the matter and submits that the matter is connected with the grant of electric connection. Accordingly, the matter is WPA number 18478 of 2024 is released from the list of this court with the liberty to the parties to mention before the appropriate court having determination.
Your lord,
that petition approach the Central Court or Central Court dismiss the writ. But against that, one of the division preferred and one of the division was fixed to divide the petition into original. Now, what happens during this indirect number, there is an arbitration proceeding that is already initiated by the railways. Now, because of the pendency of this honorable single bench's writ petition, is standing in the way. The arbitration is going to once again happen on.
What is challenge in the writ petition?
Termination of the contract of the railway overbridge.
So what is the subject matter in the arbitration?
The same.
So why you are parallel proceeding? How the parallel proceeding will go? So either you not press the petition, you go and proceed with the arbitration.
That's what I was saying before. This matter could be mentioned, but under that it could be mentioned. I'm pressing your lordship.
Let's go. Give. इसको to be men वाला है ना, to be mentioned में रखना for withdrawal.
may I permit? Your lordship.
For withdrawal. हाँ? हाँ. 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 When your father died? Huh? 2020. When the mother died? 23. Now we are on 25 you filed. 24 you filed. So उसको ले लो 25 तारीख को रखो 25
One matter. Hospitals are running in my property. Without any license or under technical establishment.
yes
Hospitals are running on my property matter without any license under clinical establishment. There is already an improvement letter issued by the CFC, the medical officer. Find out that hospital has not taken any step because they are stopping of the business matter. They are running my property. Any untoward incident happens, I will pay back.
So what is the urgency in that?
So they're running it in spite of the improvement notice, they have to stop the business without
Ah.
any license, they're running this business, my lord.
So what is the urgency?
My lord, this is my property interpretation, my lord. If any untoward incident happened to the property.
25 तारीख को रखो उसको.
My lord, may I be permitted to mention a matter, my lord? It's running, item number in the list, item number 464 and 465, the two matters. The petitioner is the leaseholder and it is the.
What is your prayer?
The upgradation.
Why? For what?
The property is under KMD, my lord.
What is the urgency for upgradation?
The original leaseholder is, the condition is not very well. So he's in serious condition. So we need her in this matter.
So what you prayed for? What is your prayer in the writ application?
My lord, regularization of the, my lord, lease deed, my lord. Original assignee, my lord, assigned it in my favor. Lease of 999 years. But so he or she can transfer it in favor of anybody else. My lord, last 13 years, my lord, she submitted in every document. My lord, in support of assignment. But since last 13 years, the matter is, my lord, hanging over, my lord.
26 February को रख दो उसको.
Lordship, may I be permitted to mention three matters, your lordship?
26 February.
For withdrawal.
Withdrawal, lordship.
Kallela withdrawal.
Item 280. Grateful, lordship.
It is listed today.
Yes, lordship.
Record or not. Give the number.
Lordship, the item numbers are mentioned.
What is the item number? Give the item number. Give. Item number 282. Counsel for though the matter is listed as item number 282, but the learned counsel for the petitioner prays for she has instructions to withdraw the instant case. In view of the submission made by the counsel for the petitioner, WPA number 17555 of 2025 is dismissed as withdrawn. Interim order, if any, stand vacated. Same item number 291, same order, and 312.
One, your lordship.
291 and 312.
12, lordship.
May I have my lord's kind leave to mention a matter? May I have my lord's kind leave to mention a matter? My lord, despite a peremptory direction from the Honorable Coordinate Bench, the respondent bank has not released the funds. The said funds are lying with the bank since the last 20 odd years. The petitioner who had filed the writ petition has passed away during the pendency of the writ petition. The successors, they have been substituted. My lord, the matter was returnable on the 1st of December, but the matter did not come up in the list. If my lord would kindly...
25th February.
25th.
May I be permitted to
Deeply
make
obliged, my
one
lord.
upgradation, my lord?
For what?
My lord, I'm staying in a property, my lord, which I received as a gift from my grandparents, my lord. Now my grandparents, being the private respondents, have filed an application under section 4567 of the Welfare and Maintenance of Senior Citizens Act to oust me from the house, my lord. I'm staying in the house, my lord. I have filed an appeal, my lord, that is still pending. In
So what you want?
Magistrate court, my lord. My lord,
It is pending before the magistrate. What the writ court will do?
my lord, my prayer is to my lord to overlook the, my lord, initial order of the initial order where I am being directed to go away from the house, my lord.
So you
Yes,
challenge the order before the revisional court. How the writ petition? Yes.
But the petitioner's grant for EWS certificate has been the petitioner's grant for EWS certificate has been rejected by the authorities due to his inclusion of his subcaste in the state OBC list.
Correct.
Now, my lord, he had participated in the second SCPC recruitment process, the document verification of which is to conducted in the last week of January. This matter was taken up
Which category you applied for?
under EWS category.
But you are having now it has been changed to the OBC category B.
Yes, my lord, category B. Now,
Category B.
Now, my lord, the urgency is that the document verification process be conducted in the last week of January. My lord, kindly takes it up before that, my lord. Otherwise, my lord, my candidature will go.
29 January.
29.
My lord,
But before that, my lord, in the last week of January, the document verification.
I can't fix on other date. 28, 29 only this.
29, my lord, deeply obliged. my lord.
Lordship, may I leave to one matter, Lordship, the petitioner is Lordship, senior citizen matter, Lordship, the pension matter, which has been deducted hugely at the time of Lordship retirement.
So why before this court? Which department?
Lordship, education, but.
Go to the education.
Lordship 2025, I have filed. They are not, Lordship, producing in document. Lordship, kindly consider this.
Madam, this court is not having the determination. You go to the education department. Irrespective, all the things cannot be taken.
Madam, may I-
Lordship, the 2023 year, Lordship, I have seen Lordship, your Lordship is jurisdiction 20.
So what? Go to the first court. If their that court will not accept, then you come before this court.
Lordship, this court is, Lordship.
This court is a good. Go to the group 2. Yes.
my lord, may I be permitted?
The mention will not finish. 1 hour has passed.
Mr. Banerjee,
Yes, one by one. Yes.
my lord, Mr. Banerjee will mention the matter item number 324. It fixed for 5th February. My lord, kindly fix any time, my lord, on 5th.
I don't know which matter.
My lord, it's a freezing of the bank account SDFC Bank item number 324 today's late, my lord.
So it is fixed on 5th February.
5th February.
That is urgent motion. So it will be taken up.
My lord, any time, my lord.
Time can't be. Time then it will go to the March.
My lord, motion, similar motion, your lordship had in earlier occasion and file.
What is
Direction given to file report by the DM. My lord, DM has already filed a report in favor of me. Panchayat Samiti constructed building of the Panchayat, Gram Panchayat office. My lord, by filling up a pond that is 20 bighas, more than 20 bighas of pond. Your lordship directed to file a report in favor of me. My lord, in spite of direction, my lord, of the SDO, my lord, the construction, my lord, 3+2 construction already done. Any date as your lordship convenience, kindly, my lord, take up as upgraded motion. Any date with notice I am mentioning.
17th February.
17th February.
My lord, may I be permitted to?
Yes. Call the list.
My lord, I mention for application.
For what?
আমি একটা ইন্টারিম অর্ডার আমি ইন পারসন অ্যাপিয়ার করছি
Which petition? Read petition.
আইটেম নাম্বার 311
So what is the urgency?
আর্জেন্সি এটা একটা হ্যান্ডরাইটিং এক্সপার্টের জন্য কোড ডাইরেকশনের প্রয়োজন আছে হ্যান্ডরাইটিং এক্সপার্ট
petitioner?
হ্যাঁ আমি ইন পিটিশনার
আপনার রিট পিটিশনার?
আমার রিট পিটিশন মানে এটা আমার বাবার লাইসেন্স এক্সাইজ লাইসেন্স
What you prayed for?
আমি প্রেড ফর মানে আমি চেয়েছি যেটা অ্যাপ্লিকেশন ফর হ্যান্ডরাইটিং এক্সপার্ট মানে অ্যাপয়েন্টমেন্ট ফর এটা অ্যাপ্লিকেশন করেছি
23 February को करो.
My lord, may I be permitted to mention?
Yes.
মানে এটা
What is the urgency?
ফিক্স করে দেন
I'm in custody for more than 21 years. My brother who was in custody, he has expired. My sister in law, she was released by the order of the governor. But I am in custody for last 20.
You have not been given the remission. Why?
But I have not.
You do one thing. You file it. Get the number. Mention. I will.
My lord, next week একটা ডেট ফিক্স করে দেন next week
23rd February.
23rd February.
My lord, may I be permitted?
Hearing matters, my lord.
Hearing matters.
Hearing matters.
My lord, I seek your lordship's leave to mention one matter for upgradation, my lord. My lord,
Come Monday.
My lord, may I be permitted to mention?
Just call the list. Call the list.
For release from this.
Which matter?
Your lordship, I had mentioned on 9th of January. Your
Which
lordship,
matter?
it is not running in the list, your lordship. I had mentioned for grounds of upgradation, your lordship had directed that because this is related to MSMED Act, violation of MSMED Act as well as SARFAESI Act. On 4th of December, I had mentioned your lordship had directed the matter to appear because your lordship said that since it is also related to SARFAESI Act, your lordship do not have the determination.
So it has to be seen. What is your prayer?
A prayer.
Your challenge is SARFAESI Act or your?
I am challenging the MSMED Act. I'm actually challenging the MSMED Act.
So that has to be seen.
Yes, I had mentioned on 4th of December upon
12 तारीख को रखो.
My lord, may I be permitted to mention?
Of today's list, kindly take it around 3 p.m. Because considering the urgency, your lordship, the actual direction matter appear under the heading.
You go to the original site registrar and tell the original site matter not to be taken. Request this court to not to taken the original site matter. Your appellate site matter will be taken. You knows that at 3 p.m. the original site matter has been taken. Then
Before 3 p.m. lordship.
My lord, may I be permitted to mention one matter for upgradation, my lord? Item number 72 of the daily list, my lord. The bank authority has withheld the petitioner's FD amount even long after maturity, my lord. The FD amount have matured
24th February को रखो.
For upgradation, my lord, item number 307 and 308 of your lordship's list, today's list. My lord, the urgency is that taking advantage of a wrong recording in the deed of conveyance, my lord, the
the local club is taking possession of my property, though the description of
What
the
you prayed for?
my lord, I'm praying for a direction upon the registrar to
25th February.
my lord, I'm deeply obliged.
25th February. Yes, call the list.
Appearing for the petitioner.
Call the list. Call the list.
Lordship.
This court did not find any justification to the assertion made by the respondent that the ongoing investigation will adversely impact it and will cause severe detriment to the public servant. In view of the above, lookout circular is set aside.
Deeply.
Next.
I am appearing for the petitioner, my lord.
It is mandatory on the part of the bank that in reply, if borrower claims benefit of the framework with reasons and affidavit, the bank is bound to look into the claim of the borrower. Considering the above, this court finds that the proceeding initiated by the bank against the petition is at the initial stage, and there is no dispute that the petition number 1 is MSME. The petitioners are directed to file claim within a week from the date along with an affidavit and the documents to the respondent number 2. If the petition submits its claim within a week from date, the bank shall consider the same in accordance with the notification dated 29th May 2015 and 17th March 2016. Till the final decision is taken by the bank, the proceeding initiated by the bank shall be kept in abeyance.
I'm grateful, my lord.
Considering the above, WPA number so disposed of by directing the respondent number 2 to that is the registrar of companies, Kolkata, to consider the representation submitted by the petitioner within a period of 6 weeks after giving an opportunity of hearing to all three parties, that is the petitioner, Swatch Environment, and the Haldia Water Services, by passing a reason and speaking order after giving an opportunity to all the parties. Next.
My lord, I am appearing on behalf of the petitioner. My lord, this is the matter wherein we were discussing whether the senior citizens, they have the, we know they have the right to prefer appeal, but whether the persons who are not the senior citizens in the same act, what they will do? Shall they prefer appeal, or they have the right to prefer a writ application? But this was our point of discussion.
Dispose of, huh?
My lord, I have annexed a particular citation, my lord, there of this honorable court. If your lordship sees paragraph 25, my lord, it has been discussed. Paragraph 20, page 25, paragraph 16.
Yes.
Well, there were the discussions thoroughly, and ultimately it was stated. Before that, my lord, kindly allow me to read from paragraph 9, relevant parts, my lord. Paragraph 9 of the citation, page 17.
Yes.
On a bare reading of section 16, it appears to us that the right of appeal has been conferred only on the senior citizen or parent, as the case may be, who is aggrieved by an order of the maintenance tribunal. The wording of the said section is absolutely clear. There does not seem to be any scope for confusion. The legislature, in its wisdom, has restricted the right of appeal under section 16 to the senior citizen or parent. There could be good reason for the same. The act is a piece of legislation meant to enhance the welfare of parents and senior citizens. The said act imposes an obligation on the children or relatives as defined in section 2A and G of the act to maintain the parent or senior citizen as the case may be. Hence, possibly the legislature thought it fit to limit the right of appeal under section 16 to the parents and senior citizens. Now, my lord, I shall take your lordships to the paragraph 16, page 25.
Yes.
Relying on the decision of the Punjab and Haryana High Court in the case of Paramjit Kumar Saroya, Supra, learned advocate for the respondent number 6 argued that unless section 16 of the said act is construed as providing a right of appeal also to the children and relatives. There is a possibility of there being parallel proceedings resulting in conflict of judicial decisions. There may be an order of the maintenance tribunal with which both the parents and senior citizens and the children relatives are aggrieved. The parents, senior citizens would challenge the order before the appellate authority constituted under the Act. The children relatives would have to challenge the order by way of a proceeding under Article 226 or 227 of the Constitution before the High Court. This would give rise to an anomalous situation and possibility of conflict of decisions. Such a mischief can be avoided if Section 16 of the Act is interpreted as giving a right of appeal to the children or relatives also. We respect to the learned counsel, we are not impressed with this argument. Theoretically, such a situation may arise. However, there would be no possibility of conflict if decisions if the High Court withdraws to itself to statutory appeal filed by the parents, senior citizens. This power the High Court has whether under Article 226 or under Article 227 of the Constitution. In view of the aforesaid, we set aside the judgment so and so. So, my lord.
Yes. So, who has filed the writ application?
My lord, huh?
You are the writ petitioner?
Yes, I am the writ petitioner. I am the daughter-in-law of the senior citizen.
Where is the order of the SDO?
Yes.
Page 100.
100 of the writ petition.
100 of the writ petition.
Yes. Page number 100 of the writ petition.
Priyanka Methi is the daughter-in-law.
Yes, I am the daughter-in-law. I am reading, my lord, loudly. The matter is taken up today for hearing. The petitioner and OPs are present, heard from both the parties. In compliance of the order passed by the Honorable Justice Tirthankar Ghosh, Kolkata High Court, there was a writ application which was filed by the father-in-law, in connection with so and so. The matter was heard at length. Petitioner allegation in brief is that he gifted his business of fertilizer with a pakka building measuring 1800 square feet total in 2 floors over a 3 decimal land to his son Badshah Maiti and daughter-in-law Priyanka Maiti equally. After that, daughter-in-law Priyanka Maiti grabbed the share from his husband Badshah Maiti by a deed of gift. Actually, what happened? Deed of gift was done. Thereafter, husband also gifted the property to his wife. In way of some conspiracy, after getting the right of full ownership of the said plot, Priyanka Maiti misbehaved with the petitioner, spouse of the petitioner, and also Badshah Maiti, her husband, and driven out from house. Now the petitioner is residential, houseless, jobless, and praying for get returned his property, which he has given to the OPs by gift deed. The OP Badshah Maiti admitted the fact and stated that his wife misbehaved with him. Priyanka Maiti, the spouse of Badshah Maiti, informed.
Who is the petitioner?
Priyanka Maiti is the petitioner before your lordship.
Before the SDO.
Yes, before the coordinate bench.
No, before the SDO.
Before father-in-law. Father-in-law was the petitioner. Priyanka Maiti, the spouse of Badshah Maiti, informed to the court that the petitioner was facing a huge financial crisis and the property in question was about to auction. In that situation, she and her father stabled the circumstances by financial help. This is the submission of the wife, daughter-in-law. The Mugberia Cooperative Bank was not approving any loan until and unless whole property shop was not fully transferred in the name of Priyanka Maiti. She is mother of 2 daughters who are unfortunate enough to get any assistance from their father or grandfather. The future or security of 2 girl child is nothing but this land. This court also perused, the order of challenge. This court also perused the deed of gifts mentioned before and found the deeds are unconditional. Hence, this court orders. Here I am pausing for a moment. I am raising question whether this SDO can pass this order even. All members, that is Priyanka Maiti, her husband, father-in-law and mother-in-law will stay at their residential house without any condition. The petitioner Abhay Chandra Maiti may start again business at the shop which was gifted to Priyanka Maiti and Priyanka Maiti is restrained from creating any obstruction with the premises related to business. As the deeds are unconditional, the petitioner prayer for cancellation of the deeds is not considered by this tribunal. If there another issue arises, the petitioner may apply before proper forum. So, my lord, this was the prayer.
So you are for the daughter-in-law.
I am for the daughter-in-law. I have come before your lordships by filing this writ application because I have no other way. I cannot go before the my lord, appellate tribunal. I do not have any right. But my lord, what happened in this case? Kindly comes to page number 12 of this, my lord, recalling application.
Page number 12.
Yes, page number 12 of this of my petition. My lord, this was for abundant mistake, my lord. The conducting lawyer.
Page number 12 of which application?
Of my recalling application.
Recalling application is can number 1.
Can number 1.
So it is for recalling of the petition.
Yes, my lord. My lord, by mistake, my lord, the conducting
Where is the order of dismissal?
Yes, page 12.
Achha, that one.
Yes, my lord. He my lord, withdrew this petition. He was under the impression that there will be an appeal before the appellate forum. But the fact is, no, it was filed properly before this honorable court as a writ application. The daughter-in-law, he has the remedy before the writ court. My lord, for that, my lord, I have preferred this application for recalling. Kindly comes to page 12. I am reading, my lord.
Correct.
I am reading from paragraph 1. After skipping 5 lines, he submits that subsequent to the filing of the present writ application, the petitioner came to know that there is an appeal provision under the Maintenance of and Welfare of Parents and Senior Citizens Act 2007. True, there was appeal provision, but that is only for senior citizens.
Correct.
Yes, thereafter, accordingly, he prays for withdrawal of the present writ application with the liberty to file an appeal before the appropriate forum. Paragraph 3, in view of the submission made by the learned counsel for the petitioner, WPS such and such is dismissed as withdrawn with the liberty to the petitioner to file an appeal before the appropriate forum. Here, my lord, I am again pausing for a moment. It was a mistake, my lord. It will be a writ application. Kindly recall the order and allow me to submit before.
Yes.
My lord, first of all, my lord, this is a recalling application. In a disposed of matter, recalling application, how far is maintainable is doubtful. It should be reviewed. And my lord, now if lordship may kindly come to, this is one part of my submission. And second is if lordship may kindly come to page 26 of the judgment passed by the Honorable Division Bench, paragraph 19.
Yes.
What number purchase?
Paragraph 19. Learned counsel for the respondent number 6 argues that even assuming that no alternative remedy is available to the writ petitioner appellant, still an order of a tribunal cannot be challenged by way of an application under Article 226 of the Constitution of India. And that must be done only by way of an application under Article 227 of the Constitution. Here, my lord, the order is of the SDO, the appellate forum is DM. We have noted this point argued before us. However, we express no opinion thereon. We leave all issues open for the learned single judge to decide, including the point of maintainability of the writ petition, except on the grounds of availability of an efficacious alternative remedy in the forum of an appeal under section 16 of
the court has left open with regard to whether it should be a 226 or it should be a 227.
In my respectful submission, this is the order of the SDO. A tribunal presided by SDO. There is an appellate forum under section.
But the division bench is binding upon us.
Yes, binding up. Division bench is certainly binding upon us. But my respectful submission that it should be under Article 227, not a writ petition.
That will taken into consideration at the time of hearing of the writ application. You take that plea.
Very well. Lordship is allowing the review. Malad, subject to correction, Malad, I don't have the reference right now. Malad, so far as the recalling is concerned, after disposal, it is how far maintainable, Malad, I have. Review is maintainable, certainly, Malad, but the recalling is not. In Buddha Sai case, Malad, but I don't have the reference right now.
Here, our submission was as it has. We prayed for
that's correct. That is correct. That is correct. If the writ petition is disposed of on merit, then the review has to be filed. If any proper. Here they have withdrawn and dismissed. Kindly see the para 3.
Para 3, I have seen.
Para 3. They have withdrawn to filing an appeal, and the learned advocate could not brought the notice of this court with regard to the order passed by the division bench. Now they have brought the notice of this court with regard to the division bench order. So as per the division bench order, the petitioner is the sister and daughter-in-law of the petitioner, so she cannot maintain the appeal before the appellate authority. So now they file the writ application. So with regard to the writ petition, or 227 is maintainable. That is the matter hearing on merit.
Grateful, my lord.
The
देखते हो
petitioner has filed the present application being CAN 1 of 2025, praying for recalling of the order dated 2nd December 2025. Wherein, as per the submission made by the counsel for the petitioner, WPA number 25520 is dismissed and withdrawn with the liberty to the petitioner to file an appropriate appeal before the appropriate forum. Learned counsel for the petitioner submit that though on the submission made by the counsel for the petitioner, the court has passed an order for dismissal of the writ application, liberty to file an appeal. But subsequently, the petitioner, learned counsel for the petitioner submit that the learned advocate on record could not able to bring to the notice of this court to the order passed by the honorable division bench of this court in the case of Srimati Mamata Banerjee and another versus the state of West Bengal and others, passed in MAT number 61 of 2019, dated 19th of March 2020, wherein the honorable division bench has held that the parents / senior citizens would challenge the order before the appellate authority constituted under the Act. The children / relatives would have to challenge the order by way of proceeding under Section 226 or 227 of the Constitution of India before the High Court. The honorable division bench has kept open whether the application under Article 226 of Constitution of India is maintainable, or whether under Article 2 whether the application filed by whether challenging the order passed by the SDO can be maintained under Article 226 of the Constitution of India or Article 227 of the Constitution of India. Learned counsel for the learned counsel for the petitioner submit that there in terms of the order passed by the honorable division bench, there is no appellate provision, and as such, the petitioner has to continue with the proceeding of the present writ application. Accordingly, prays for recalling of the order and to restoration of the WPA number 25520 of 2025 in its original file. Learned counsel for the respondent raised objection and submits that this court, by an order dated 2/12/2025, has dismissed the writ application as withdrawn as per the submission made by the counsel for the petitioner, and as such, the order passed by this court dated 2/12/2025 cannot be recalled, and the application filed by the petitioner is not maintained. He further submit that the petitioner has not filed any application for review of the order dated. Had the learned counsel for the petitioner respondent further submit that the order passed by the sub-divisional officer is an appealable order under Section 16 of the Act, and as such, the petitioner has to approach the appellate authority. Had the learned counsel for the respective parties, this could find that the petitioner initially the petitioner was of the view that the order is appealable, and accordingly he has taken leave from this court to file an appeal before the appellate court. Accordingly, this court has dismissed the writ application with the giving the liberty to file an appeal. Subsequently, the petitioner came to know with regard to the order passed by the honorable division bench in the matter of Mamata Sikri Supra, wherein the honorable division bench has categorically held that only the senior citizen or parents can maintain the appeal under section 16, and the children and relatives can only maintain the writ petition either under 226 or 227 of the Constitution. Considering the above, this court find that on the misconception the petitioner has read before this, on the misconception on the petitioner has prayed before this court for withdrawal of the writ petition. Accordingly, the petition was dismissed. Now, in terms of the order passed by the honorable division bench, the appeal is not maintainable if he is not a senior citizen or parent. Admittedly, the petitioner before this is the daughter-in-law of the complainant before the subdivisional officer. Considering the above, this court find that the can number 1 of 2025 filed by the petition is maintainable for recording of the order dated census. Accordingly, order dated 2/12/2025 is recalled. WPA 25520 of 2025 is restored as an original file. List the can number census disposed of. List the matter when
February, second week.
Affidavit filed.
No.
You will file affidavit.
Lordship may kindly give.
Or argue on merit.
My lord, it's a law point, my lord. It's a law point.
Let the matter appear on 19th February under the heading urgent motion.
Lordship, grateful.
Grateful, my lord. Grateful.
Next.
19th February. Great.
Yes, call the list. 5 is 2 p.m. Na?
No, this is actually
5.
No,
8.
8. Well, this has come by mistake because your lordship had been pleased to place it on 27th January. And the first order which was your lordship.
If it is done.
No, he used to pay me compensation.
I will.
You do both. You go.
I will.
But these petitions are in fact not claim against the state. Client ASG would ultimately not be troubled with the fight between the state and center. That is before the division bench. Anyway, let it appear on 27th.
Thank you.
কিন্তু আমাকে দেরি করবে
আমার হাতের ভাই দেখছি অন্য লাইন দিয়ে দেখছি
Record. It is Learned Counsel appearing for the parties inform this court that the matter is wrongly listed today and submit that by an order dated 7 January 2026, this court is fixed the matter on 27th of January 2026. In view of the submission made by the counsel for the parties, peruse the order. Let the matter appear on 27 January 2026 under the same heading.
The subsequent order has not been uploaded. That is why it was earlier order was directed to appear on 15th.
And that is why that he should pay me compensation.
9th January is it server has been done?
No. Your lordship's earlier order was it was due to appear on 15th.
Okay.
That is why it has come.
Okay.
Subsequent order is not taken note of.
Thank you. Next.
Item 9, Your Lordship, I am being laid by Mr. Bihani. Your Lordship, due to some personal difficulty.
What is the matter?
The matter is about the passport renewal, Your Lordship.
Yes. You are ready with the report, Mr. Jagat?
Yes, well, they actually informed us that they will ask for adjournment.
Now, if you are ready with the report, otherwise
Yes.
When?
Any day next week, Your Lordship. Any day next week.
Well, after 27th.
After 27th?
First week of February.
As per the prayer made by the counsel for the petitioner, the case is adjourned. Let the matter appear on 3rd February.
3rd February.
Under the same heading.
Under the same. A copy of the report.
No.
Come on that day, we'll see to that.
Email. Soft copy for order.
10.
For the petitioner, my lord, I have already served notice of the advocate, senior advocate, and the learned government advocate.
एक काम करो, इसको ना भिजवा दो, हमारा अर्जली होगा ना, चैम्बर में भिजवा दो, करेक्शन करके अपलोड कर।
দাঁড়িয়ে আছে তিনি।
Can? What is the can? Okay, I will see in the file. I will see if it is, and I will include that.
My lord, I am paying for very short password, my lord, on behalf of Mr. Nilotpal Chatterjee, my lord. At present, he is on legs before the courtroom number 3, my lord.
Last occasion, your lordship was.
That,
Yes.
have you taken instruction? What has happened to the board?
My lord, instruction has received by him, my lord, but
Authority is required
I am
to be
not.
appointed. My lord, judicial officer has already been appointed.
Yes.
No, last time because the
Yes, I have seen the
DM
last order,
yeah.
my lord. But yes,
You have a report.
no, my lord. I
What
do not
you-
have.
what
But
you
it's- I'm paying for only very short passover, my lord.
Passover.
Kindly passover, my lord. He will come very shortly.
Password next.
11. Item number 11.
None appears on behalf of the petitioner. You are appearing for the 11.
Petitioner. Yeah, my lord, I have something to say. But there's an order directing the sons to pay maintenance. Today is the 15th of the month. That has not been paid. There's an early order of Justice Sinha directing reimbursement of medical expenses. That has not been paid. I have submitted revised bill in terms of my lord's order direction for reimbursement of the travel allowance. That has not been
You
paid.
come this side.
All that, my lord, when the matter is pending, when my lord is in season of the matter. And I shudder to think what would happen once the matter is disposed of. This month's maintenance not paid, medical expenses not reimbursed, travel allowances, the revised bill not paid. 15th of the month today.
Yes, Mr. Mukherjee.
But on my instructions, my lord, I say that, my lord, it has been paid. The transfer details are here, my lord. My learned friend, my lord, may verify
I have
from his
instructions
client.
till
I've got the
yesterday.
details.
This month's maintenance also and the medical bill reimbursement.
That we have paid, my lord, we can send the proof of, my lord.
If it is
So, my lord,
paid-
let my learned friend, my lord, argue on merits.
Yes.
Because,
No,
my lord, every month he will come and complain about
Yes,
that not
I'm
paid.
complaining because there's the other son also. He has also to pay. He has
Not the
also
man
to
of
pay
God.
the other son. My learned friend is not speaking for both of them. Until yesterday, my lord, even this month's maintenance was not paid.
Which one?
The
Mr. Mukherjee is telling that then you know, it has
Yes,
been
but
paid. They are having the
when, on which date?
9th January.
Sorry?
9th January. The 15,000 maintenance.
No, I have the proof for this one. I have the proof for the travel expenses, my lord, on my phone right away.
No maintenance.
I'll send the proof as well. I have instructions that it has been paid.
My instruction is, and the medical reimbursement is also there.
Instructions that is not paid.
He's telling that it is medical in.
No, that is, I think, travel.
That is a trial. That was a submission.
Okay.
Yes, I
Okay,
say
come
all
on, merit,
three
I will
items have not been paid.
Come on, merit. Come on, merit.
On merit, my lord, I have submitted a brief written note. I'll, my lord, focus on the second page of that, the financial capacity of the sons. And all along, my lord, the elder son is totally silent. He has also to contribute to that. This is important because this is all the more reason, my lord, why the house should be vacated and the rent paid to my client. Instead of coming forward every month before my lord with a begging bowl, but this cannot go on indefinitely. My learned CA friend is absolutely right.
Yes.
But kindly see page 2 of that 3-page note.
Yes.
The elder son Gajanand has a rice mill in Keshpur and Midnapur, and his elder son, the grandson of my client, is also earning. The elder son and his family are in occupation of the first floor of the building. His daughter has been recently married off in a lavish wedding. The younger son, Shamsundar, carries on his father's business of animal feed in Kirantala and uses the ground floor of the residence as a go down for the said business. He has also appropriated the agricultural income from the family's ancestral home land in Haryana. The maturity proceeds of the fixed deposit disclosed by him at pages 58-59 of his writ petition have been misappropriated by him. There's no whisper about what has happened to that money. The purported affidavit undertaking of Pushpa, annexed at pages 31-32 of his writ petition, allegedly recording no objection of his mother to run the family business from the subject property, bears her forged signature. Besides the ground floor go down, the younger son is also in occupation of the entire second floor of the building. This is how things are. But the house is in the name of my client. That has not been disputed. There's a wrong deed annex that has been pointed out by one of the brothers. And then the claim of the petitioner, in view of the fact that the petitioner considers it impossible to reside in her dwelling house in Midnapur because of the perceived threat to her safety, the house should be vacated by ousting the sons. In the event the Honorable Court is not now, Malad, after this change scenario of every month there's default, I think, my lord, this whatever money my lord eventually directs will not be paid.
Yes, continue.
Grow up. The petitioner cannot be expected to spend her remaining life in her sibling's house, and that is why she has claimed a nominal rent for an independent accommodation in Jatani in Khurda district, near the residence of her younger sister. It has to be borne in mind that the two sons are in occupation of the entire three-storied house, the ground floor whereof is in commercial use. Irrespective of the income of the sons, the rental income from the said property would be in the region of 50,000 per month. And as owner of the property, Pushpa is squarely entitled to the said sum. She should also be paid her share of her husband's business, now run by the younger son. In addition, the maturity proceeds of the fixed deposit disclosed at pages 58-59 should be paid to her. In the event of serious illness of the petitioner requiring hospitalization, all expenses should be borne, I say, by Shamsundar, by whatever they decide. However, in the event of the sons failing to comply with the order of the Honorable Court regarding payment, the order of eviction passed against them by the SDO should take effect. My lord will also note another significant thing. After the SDO's order, my lord, there was a gap of 6 months before the writ petition was filed. In that 6 months, my lord, not a penny was paid.
Not a penny was paid means?
As maintenance, in terms of the direction of the SDO.
10,000 you are not getting.
The direction was 25,000, 15,000 by Mr. Mukherjee's client, 10,000 by the other son. For that period, till the
Can the SDO can pass an order for 25,000 under section 9(2)?
she can, in default of rent, she can. I know there's a ceiling on that, but then the deemed rent, the deemed rent, the property is hers.
So deemed rent can the SDO can decide in the summary proceedings.
But it cannot. Kindly have a look at the prayers of his writ petition.
That's why I kept this matter. These are the two questions. Section 9, there is a ceiling of the maintenance amount, which cannot beyond that. If it is ceiling, so you cannot go beyond the 10,000 rupees. With regard to the property, income of the property you are claiming, so that cannot be decided by the authority.
25,000 has not been challenged by either party.
No, I am telling here.
Yes.
Whether they have challenged or whether the authority, if this court is find that it is beyond the jurisdiction, the court can so moto can pass an order.
Even there is a writ petition by my client.
All this is that they are the only challenges to the eviction direction. But this is all the more reason, my lord, for the house to be vacated. The tenant being placed there and the rent coming to my client.
Because kindly come to the section 4. Section 4, then now come to section 9.
And then Lord 11.
11.
Implementation.
Section 4.
Section 4. Section 4 is your application.
Yes.
Which you have filed the application before the authority. Section 4 read with section 5. 5 is the application, 4 is the maintenance.
Here the presumption is that the senior citizen is residing in a house, own house. The question of rent, deemed rent, occupation charges did not arise.
From the law. Now it is before the court. Now the court has to go by the law.
Kindly seize,
I think the prayer is only for delivery of possession of the house, Lord. That is also not maintainable in a writ court.
Kindly seize, my lord.
Writ petition is
Section 4. Section 4.
Yes. My learned friend is arguing.
Section 4. Any person being a relative of a senior citizen and having sufficient means shall maintain such senior citizen provided he is in possession of such property. Section 4, subclause 4.
Correct. Yes, I am there.
Yes. or he would inherit the property of such senior citizen.
Correct. Now kindly come to the 9.
Yes. If children or relatives, as the case may be, neglect or refuse to maintain the senior citizen, being unable to maintain himself, the tribunal may, on being satisfied of such neglect or refusal, order such children or relatives to make a monthly allowance at such monthly rate for maintenance of such senior citizen as the tribunal may deem fit and proper.
And you also filed the appeal. You have filed the writ petition.
I filed a writ petition.
So you are the senior citizen.
I am for implementation of the order.
Implementation. Okay.
The maximum maintenance allowance which shall be ordered by such tribunal shall not exceed 10,000. But here, my lord, 10,000 may be construed by each of the sons. There is a separate direction on respondent number 5 and 6. 5 is 10,000 and 6 is 15,000, a figure which has not been challenged. The focus on their writ petition was on the eviction order. In all this scenario, the proceedings, the happenings in the course of the pendency of the writ petitions embellishes the case for having the house vacated and a tenant being put in place, my lord, so that the rent can be enjoyed by my client. And my lord, the harassment and the neglect that the petitioner faced at the hands of her sons, kindly see page 4, paragraph 4 of the first page of the writ petition. There's the reference to the pleadings in the writ petition, the sufferings and humiliation suffered by the petitioner at the hands of her sons after her husband's death are narrated in paragraph 6:1 to 6:25 at pages 4 to 9 of her writ petition. She was thus compelled to take refuge in her sibling's house in Orissa in March 2019, where life-saving kidney surgeries took place on 18th April and 14th June 2019, followed by surgery for removal of cataract of her eyes. She returned to her residence in Midnapur from Orissa in October 2019, but her stay there was not happy as her sons displayed total apathy, failing to provide food and medicines, and even worse, treating her with scorn and ridicule. The petitioner was thus left with no option but to shift to Cuttack in January 2023. Just one judgment, my lord, that although eviction is not to be normally ordered, in case of persistent humiliation and, my lord, apathy and just kindly bear with me. Yes, this is a very recent judgment, my lord, of the Supreme Court. Kindly sees paragraph 28 of this. 2025 Supreme Court cases online, page 669, paragraph 28. 2025 SCC online, SC 669. It was only in the contingency of Krishna Kumar, that is the son, not behaving properly or continuing to.
Where?
Paragraph 28.
Yes.
I hope I have given my lord the right judgment.
Yes.
Continuing to humiliate or torture the parents, that the eviction proceedings would be necessary against him. Here, even during the pendency of the writ petition, my lord, maintenance not paid. She had to run away from there because of the scorn, the humiliation, the apathy shown by the sons. Here, the eviction order was set aside, but with that rider.
Where? Which?
Paragraph 28, my lord.
Yes, in concerning Krishna not behaving properly, continuing humiliate, torture parent, eviction proceeding would be necessary against him.
That here, my lord, the client was present before my lord. She could not be persuaded to.
That's why the eviction proceeding would be necessary against him. So eviction proceeding where?
Eviction proceedings before the tribunal.
How? Under which provision?
That again, my lord,
Only under 23 permission. Not under
Section 23 has been read with Section 4 have been interpreted by Supreme Court that, my lord, that has to be read into it. Just the case of Vanita, that judgment is before my lord, my lord.
Correct, but you have what application you filed?
Kindly seize the judgment, Vanita. Here, my lord. I'll place Vanita. I just
Kindly come to the first 23.
Yes.
It's not a case under 23.
Correct.
so-
Whether
It is not a case under 23(1).
That's why whether there is any gift.
No, that is subclause 1. Subclause 1 of 23.
Where a senior citizen has a right to receive maintenance of the estate, some part thereof transfer the right to receive maintenance.
Here, this transfer has been interpreted by Supreme Court and other high courts also. But this judgment is with my lord.
Which order? Which order?
2021-15 SCC 730.
Yes. Vanita.
Yes, yes.
Correct. This is
I cited this
Yes.
not to show
I
the
also
primacy
rely on
of
this.
not the act.
Paragraph 24.
24. Yes.
Kindly reads paragraph 24 and 25. But I'll start from 23 actually. On the other hand, subsection 2 of section 23 envisages a situation where a senior citizen has a right to receive maintenance out of an estate. Where such a right exists, the right of maintenance can be enforced where the estate or a portion of it is transferred against a transferor who has notice of the right, or the transfer is gratuitous. The right, however, cannot be enforced against the transferee for consideration without notice of the right. Now, subsection 1 of section 23 envisages a situation where this subsection 1 is not relevant, but on the other hand, subsection 2 of section 23, for a few lines below that,
Yes.
does not confine itself to transfer by a senior citizen, unlike subsection 1. Subsection 2 uses the expression such estate or part thereof is transferred, where a senior citizen has a right to receive maintenance out of the estate and any part of it is transferred. Subsection 2 permits the enforcement of the right to receive maintenance out of the estate against the transferee with notice or against a gratuitous transferee. Subsection, in other words, may cover a situation where the transfer of the estate in which a senior citizen has the right to maintenance is by a third party, in which event the provision provides the right to enforce the claim of maintenance against such transferee. Arguably, the language of subsection 2 is broad enough to cover a situation where the transfer is by the senior citizen, in which event the transferee with notice of the right or a gratuitous transferee can be made subject to enforcement of the right against the transferred estate. Here, the transfer is not absolute transfer, but transfer of possession. But the transfer has not been defined, my lord, and in the subsequent paragraphs, my lord, kindly see paragraph 24 now. Another distinction between subsection 1 and subsection 2 of section 23 must be noticed. Under subsection 1, where a transfer has been made by a senior citizen subject to the condition that the transferee will provide for the basic amenities of his physical needs.
That is a fraud.
Yes. Now, a few lines below that, Mullah, the fourth line from the bottom, subsection 2 in contradiction stipulates that the right to receive maintenance can be enforced against a gratuitous transferee or a transferee with notice of the pre-existing right of a citizen to receive maintenance out of an estate, notwithstanding who is the transferee of the estate. In keeping with the salutary public purpose underlying the enactment of the legislation, the expression transferred also not only be absolute transfer, but also the transfer of the right or interest in the property. This would also be in consonance with the provisions of section 2F, which defines the expression property to include rights or interests in such property. Here I mean possessory rights. The expression transfer not having been defined specifically by the legislation, it must receive an interpretation which would advance the beneficent object and purpose of its provisions. Subsection 2 of section 23 speaks of the enforcement of the right to receive maintenance, which is more comprehensive in nature than merely enforcing an order for maintenance passed under section 9 of the Act. And paragraph 23. The substance of subsection 2 of section 23 as submitted by the second and third respondents is that the tribunal had the jurisdiction to pass an order directing the eviction of the appellant, who is the daughter-in-law. According to the submission, the power to order eviction is implicit in the provision guaranteeing the right to receive maintenance out of an estate, and they are the enforcement of the right. When here, my lord, that is the daughter-in-law who had competing claims under, my lord, Domestic Violence Act and that. But the important thing is that the definition of transfer is not confined only to absolute transfer of the property, but also to possessory rights of the property under section 23(2). Eviction, in other words, would be an incident of the enforcement of the right to maintenance and protection. However, this remedy can be granted only after adverting to the competing claims in the dispute. I'm reading on from paragraph 25.
Yes.
This, I rest my case squarely on this. There's no document transferring the property, but here the possession has been transferred. It is my property. That is not an issue. The quantum of maintenance has not been disputed. My lord will inquire from the respondent number 5 whether he is paying the maintenance.
Okay, that's all.
Yes. But there are judgments following from this, my lord, by various high courts. I can give my.
Completed, then because Mukherjee already argued what further, because of you only it has been kept.
Yes, and because of my anxiety that once the writ petition is disposed of, nothing will come.
No, your writ petition is for enforcement. Their writ petition is regard to the challenge. If this court find that their challenge is not sustainable, then
Challenge to
enforcement.
the eviction. No
Correct.
challenge, my lord. Will kindly look at the
Correct. With regard to that, the court has to pass an order. Yes, आप पैसा दे रहे हैं कि नहीं दे रहे हैं? कब दिए हैं? Last payment कब दिए हैं? लास्ट पेमेंट कब दिए हैं? अभी हम जनवरी में हैं. कौन सा महीना में पैसा दिया आपने? December. Yes, paid.
December. We are now in the middle of the next month.
Yes. जनवरी में क्यों नहीं दिया आपने? अभी जनवरी बढ़ा हुआ क्या? 10 तारीख तो कंप्लीट हो रहा है. तारीख हो गया. थोड़ा प्रॉब्लम है. प्रॉब्लम हो जाएगा यहाँ से जब ऑर्डर होगा तो. अभी तक तो अथॉरिटी का ऑर्डर, हाई कोर्ट का ऑर्डर होगा तो प्रॉब्लम सब बाहर हो जाएगा आपका. अब मदर को पैसा नहीं देना चाहते तो फिर और मतलब क्या है आपका? दिया है तो अगला महीना में तो दिया, इस महीना आप कोई मेहरबानी नहीं कर रहे हैं अपने मदर को पैसा दे करके. फिर दिया दिसंबर का भी दिया हुआ है, जनवरी का. आपका क्या बोलना है इसमें? आप ये आपने तो अपील नहीं डाला है ना?
Your lordship will.
हाँ, क्या बोलना है बोलिए.
हमारे पास कोई काम नहीं है.
हाँ,
बेकार.
ठीक है.
थोड़ा भाड़ा उड़ा से इनकम आता है, फैमिली का.
ठीक है.
फिर भी हम ये उधारी लेके देते थे आपका जो बोला था वो हम निकाल देंगे.
ठीक है.
और ये जो लोगों का जो चीज था, जो भी कुछ हमने खाली 2 लोग यूज करा. बाकी का नंबर आए क्या है वो ये वाला चीज है. अगर हमको
आपने तो चैलेंज नहीं किया है ना? एसडीओ साहब ने जो ऑर्डर किया आपको 10 आप देने के लिए राजी है तो ठीक है. ओके.
Lord, if your lordship kindly comes to the prayer of Lord, my learned friends, Lord, writ petition at page 14. Mandamus is short, Lord, directing the respondent number 5 and 6. My client and the other brother. You are at page 14. Lord, that is Pushpa Sharma's Lord writ petition number 10504. The 2 writ petitions.
Yes.
The writ of or in the nature of mandamus directing the respondent number 5 and 6 to hand over vacant possession
Yes.
of the immovable property belonging to her at such and such, comprising of 2 katas land with 3-story structure in terms of the order of the SDO. So, my lord, this is the first prayer. The second prayer, Lord, that is what I mean to say is a mandamus is sought against Lord a private person seeking Lord delivery of possession of a property. First prayer. The second prayer is Lord compliance of Lord the 2 of the orders.
That's the maintenance order.
So that is the maintenance order. Now, Lord, the maintenance order, as your Lordship will find, Lord, is having 2 components of it. The 2 brothers are Lord supposed to pay Lord 10,000 and 15,000 each.
Correct.
Now, Lord, it was also stated that they will not deliver vacant possession of the building.
Till that period.
No, Lord, yes. Page 79.
Page 79.
Page 79.
Yes. No problem to vacate the property to the applicant, but ask the reasonable time for safety.
Lord, about the middle portion, opponent number 1 and 2.
What is your contention with regard to this admission? You will vacate the property.
But this was not our contention at all. Because this could not have been there. Because Lord, when I take your Lordship to their application was for maintenance. There are 2 sons and a married daughter. They were all impleaded. Orders have been passed against Lord 2 sons. The order is Lord 10,000 for Mr. Sharma, Gajanan Sharma, and Lord for my client Shamsundar Sharma, it is 15,000 rupees.
Correct.
So far as the quantum of maintenance, Lord, I say when I refer to section 9, Lord, there is a capping of 10,000 rupees. We did not Lord contest on that before your Lordship. We agreed. Well, our only point was, Lord, before your Lordship, whether on an application under section 5, Lord, without a prayer, Lord, this Lord,
where is the application?
Yes, Lord, your Lordship will kindly come to their application, Lord. Page 69. No. Page 60. Yes. And she files this Lord while she was staying at Cuttack, the sister's place.
There is the prayer. What the prayers she has made there.
Now, Lord, your Lordship will see, Lord, there are 3 Lord children. Names have been there.
That is there. Where is the prayer?
Then, Lord, amount of maintenance 7. That is at page 71.
Yes.
30,000 per month reimbursement of hospital expenses. These are the 2 Lord amount of maintenance claimed. Then, Lord, the details of the property owned by the applicant, Lord, the land such and such, Lord, which we say that this is not absolutely owned by her. This being a Mitakshara property, the property was owned by the father. Therefore, Lord, it is co-owned by all the legal heirs. So, Lord, there is also, Lord, a mention of, Lord, a movable property, the funds at a Mahendragarh Central Cooperative Bank, Haryana. So, Lord, the prayer were only for 30,000 rupees and, Lord, hospitalization expenses. Nowhere, Lord, there was a prayer. It could not have been, Lord, in a section 5 application. The purpose of the act, Lord, is to, Lord, ensure that the senior citizen is maintained.
Yes.
So, Lord, in this context, Lord, your Lordship has already seen, Lord, the orders, the 2 orders. Now, Lord, our only contention is that, Lord, on an application under 5.
So that order is 79.
That order is 79, Lord. And there is another order, Lord, page 88.
Page 88, yes.
These are the 2 orders.
Yes. Yes.
Now, my lord, your lordship has seen, my lord, the scope of an order for maintenance, section 9. But if your lordship will kindly take, my lord, the statute now.
Yes.
If children or relative, as the case may be, or neglect or refuse to maintain a senior citizen being unable to maintain himself, the tribunal may, on being satisfied of such neglect or refusal, order such children or relative to make a monthly allowance at such monthly rate for the maintenance of such senior citizen as the tribunal may deem fit, and pay the same to such senior citizen as the tribunal may from time to time direct. The maximum maintenance allowance which may be ordered by such tribunal shall be as may be prescribed by the state government, which shall not exceed 10,000 rupees per month. So there is a upper limit. The needs of such citizen, so that senior citizen may lead a normal life. At any event, it cannot be, as provided in subsection 2 of section 9, more than 10,000 rupees per month. Of course, while allowing even lesser amount, the income of the appropriate party should be taken into consideration. So, my lord, here, when I take your lordship to the order, your lordship has already seen, my lord, it is 25,000, my lord, as against 30,000 rupees claim, which is absolutely contrary to, my lord, subsection 2 of section 9. This is, my lord, one part of the order. On instruction, my lord, I do not say anything on the quantum. Now, my lord, when it comes to, my lord, the prayer B of my learned friend's writ petition, my lord, the enforcement of an order of maintenance, my lord, we fall back upon section 11. So there is an efficacious alternate remedy. A copy of the order of maintenance and including the order regarding expenses of procedure, as the case may be, shall be given without payment of any fee to the senior citizen or to parent, as the case may be, in whose favor it is made, and such order may be enforced by any tribunal in any place where the person against whom it is made, such tribunal, on being satisfied as to the identity of the parties and non-payment of the allowance, as the case may be, expenses due. A maintenance order made under this act shall have the same force and effect as an order passed under Chapter 9 of the Code of Criminal Procedure 1973, and shall be executed in the manner prescribed for the execution of such order by that code. So, my lord, twofold, my lord, execution.
Yes.
By the tribunal itself, and, my lord, by resorting to, my lord, CRPC.
Yes.
Now, my lord, the right of appeal is only vested, my lord, to the senior citizen. My client doesn't have the right of appeal under section 16. So, my lord, my only remedy was filing, my lord, the writ petition before your lordship. Now, my lord, so far as, my lord, the second prayer of my learned friend's writ petition is concerned, my lord, they are to be relegated, my lord, under section 11 to the authorities concerned. But they do not have any right to approach this honorable court. Now, my lord, the other point that my learned friend had taken, my lord, that when an order for maintenance is passed under section 9, my learned friend tries to contend that it also encompasses eviction, so that, my lord, the senior citizen can, my lord,
take the benefit,
take the money by, my lord, renting it out. Now, my lord, to such effect, my learned friend was trying to take, my lord, the help of section 23, which is, my lord, categorical on the point about, my lord, when there is a transfer made.
Correct.
And the transfer is, my lord, essentially a transfer contemplated under the Transfer of Property Act. Not, my lord, what my learned friend, my lord, says about the possession. The possession was never, my lord, taken. On the last occasion, your lordship has recorded in the order, when your lordship asked her that whether she is willing to reside, she categorically said, no, I am not willing to reside at Cuttack, not with my sons. So, my lord, it is not even a case that she has been turned out from the home. A transfer of property to be void in certain circumstances where any senior citizen who, after the commencement of the act, has transferred by way of gift or otherwise his property is subject to the condition that the transferee shall provide the basic amenities and basic physical needs to the transferor. As such transferee refuses or fails to provide such amenities and the physical need, the said transfer of property shall be deemed to have been made by fraud a coercion or undue influence, and shall at the option of the transferor be declared void by the tribunal. So, my lord, there are two elements to this. There must be a transfer. The transfer must record that it is in lieu of maintenance. And if there is a breach of, my lord, the condition of transfer, then only, my lord, 23 is resorted to.
Correct.
Then, my lord,
whether you find any document to show that the property belongs to father and
nothing. Lord, there was no prayer even under 23. Lord, because there could not have been a prayer because there is no transfer by, Lord, the senior citizen.
Okay.
Because, Lord, to invoke 23, there must be a document of transfer with a stipulation of maintenance. There is a judgment which says that if there is no stipulation of maintenance, Lord, then it doesn't fall under 23. It is an unqualified gift or a transfer. It has to be a qualified gift to fall under 23. Then, Lord, subsection 2 says, where any senior citizen has a right to receive maintenance out of an estate, and such estate or part thereof is transferred, the right to receive maintenance may be enforced against the transferee if the transferee has notice of the right, or if the transferee is gratuitous, but not against the transferee for consideration and without notice of right. But this is a very important, Lord. Although the Supreme Court tried to make a distinction qua, Lord, the PWDV Act, but here independently, Lord, what it says is that, Lord, suppose a property is there.
Yes.
And the property is not transferred.
Correct.
With a right to receive maintenance is attached out of that estate. Then, Lord, it can be enforced against the transferee. If the transferee has a notice of such right.
And that's
but if it is for consideration, no. But not against transferee for consideration and without notice of right.
The right to receive maintenance may be enforced against the transferee if the transferee has notice of the right. Or if the transfer is gratuitous, but not against the transferee for consideration without notice to right. Now, kindly come to the paragraph 20, this judgment of Vanita.
Lordship.
Paragraph 25. Paragraph 25, 1, 2, 5, 6, 7, 8,
The
9.
substance of subsection 2 of section 23 as submitted by the second and third respondent is that the tribunal had the jurisdiction to pass an order directing the eviction of the appellant who is the daughter-in-law.
Correct.
According to the submission, the power to order eviction is implicit in the provision guaranteeing a right to receive maintenance out of an estate. But this is the submission according to the submission.
Yes.
And the enforcement of that right. In supporting the submission, they have referred to the view which has been taken by several high courts indicating that the tribunal may order the eviction of a child or a relative from the property of a senior citizen where there has been a breach of the obligation to maintain the senior citizen. The tribunal under the Senior Citizens Act 2007 may have the authority to order an eviction if it is necessary and expedient to ensure the maintenance and protection of the senior citizen or parent. Eviction, in other words, would be an incident of the enforcement of the right to maintenance and protection.
Yes. So they can take the recourse at the time of enforcement.
Yes. But suppose I do not pay.
Correct.
Then
Enforcement
the
right.
Supreme Court says that, well, you can take this recourse.
As like an attachment.
Not independently, not as my learned friend is trying to say. However, I'm not reading the other portions. That is immaterial for our purpose.
Yes.
So, Lord, coming back, Lord, to the point that my learned friend has taken, Lord, in his application for maintenance simpliciter, Lord, the authority has gone, Lord, and Lord, assumed jurisdiction not vested to it by law by saying that, Lord, we have to vacate the property. And thereby, Lord, creating a ripple in the family. But that's all for myself.
Thank you.
But if your Lordship, Lord, we have prepared a written notes, your Lordship will kindly, Lord, have you printed it?
No, there's the section 3, my lord, which confers overriding effect on this particular act. So Mitakshara law has to take a backseat. And on facts,
Lord, we can consider that when there is a civil suit on that point.
That you go to the partition suit, then the Mr. Mukherjee will take the override effect of
Roman 2, page 4, Roman 2. There's a pleading that your petition is the absolute owner of a 3-story residential building.
Page 4?
My writ petition.
Achha, your writ petition.
Page 4. The assertion that she is the absolute owner, this has not been denied in the affidavit.
Page 4, Roman 2.
Yes.
Husband of the petitioner passed away and the cancer petitioner is the absolute owner of the 3-story residence. P1.
So P1 is, it has been rightly pointed out by this respondent, Malad, that is a wrong deed. This particular property was sold, but they have not disputed that the property in contention, Malad, belongs to my client.
ये जमीन किसकी है?
ये मालूम नहीं है।
हाँ?
पूर्वजों का
ये जिसमें जो जमीन आप अभी जो आप रहते हैं, दुकान है, वो किसका है?
मालूम नहीं है, वो पूर्वजों का है।
मालूम नहीं आप वहाँ रहते हैं?
That
आप कहाँ पे टैक्स नहीं बनते? कुछ नहीं देता, बढ़िया।
Yes, ever since her husband's death, nobody has been paying the taxes.
Okay,
that's all. Thank you.
Look, the written notes, Lord, I'm told it is ready.
Give to my court office.
By tomorrow, Lord. By tomorrow.
Hearing concluded. CAV. ओ कल उन रिटर्न नोट्स देंगे ना, इसमें रख देना।
But there's a order of Justice Sinha, Malad, September 9th, 2025, directing reimbursement of medical expenses in the ratio directed by the SDO. That is 2/3, 15,010. So that order is.
That was an interim order, Lord.
Yes,
Now
that has not
Lord,
been
we have
complied.
already shown that we have
That has
given
not been
payment.
complied.
पैसा दीजिए आप। वो तो दिसंबर में दिया, अभी आज कितना तारीख है? तो कब देंगे आप? मैं कल रखूं, मैं वो डेट में रखूंगा फाइल मैं केस।
4 बजे उठ के आना पड़ता है और ठंडा बहुत ठंडा है
ना not say yes next
but this is the order directing reimbursement of medical expenses. 24th September 2025 in this writ petition. So
फाइल रब में रख दीजिए। Yes, call the
this nobody's case that they have made the payment.
3টা পাসওয়ার্ড ছিল 3 Hello, may I please the report, Lord? My Lord, Hindi is very mellifluous, Lord. Should I give one copy to my learned friend, Milord?
Yes, give.
First query is, Milord, ওটা অ্যাডভার্টাইজমেন্ট হয়েছে দেখো
Lord, the advertisement speaks that last date of the receipt of the application is 6th March 2026. That is far off, Lord. And then thereafter, my Lord, the mental
No, in here the members have already been appointed.
except, my Lord, only district nominee.
Huh?
Only district nominee. That is absent.
Correct. Now kindly come to the page 2. Page 2 in terms of 74B, mental health and also compliance of the order of the census and so. The state of West Bengal.
May be nominated by the principal secretary.
Yes. So now the principal secretary has to nominate the.
that will be done, Milord.
Done.
Query was of the court, Milord, in case where the district magistrate is not there, who will be the officer? That is answered.
Clarification has come now.
Right.
And, my Lord, for that reason, my Lord, they have given the advertisement. My Lord. That is the page 3.
Correct.
And my lord, it is mentioned in the said advertisement, last date of receipt of the application 6 March 2026.
Correct.
And that is part of my lord, because this matter is pending. It is a
No, earlier you stated that there was a committee, only this chairperson was there, but the special,
yes.
where is that? Where that has been superseded?
My lord, my lord, on 23rd September 2025, they have filed the report. And in the said report, they have said that till the selection of non-official member is completed for the majority of district, the other official member of MHRB of the district are requested to carry the function in respective districts under the respective chairman of the district.
Correct.
And the my lord, the district magistrate is the chairman of the district.
Correct.
And my lord, here, my lord, as because this is within the jurisdiction of the Calcutta, and the Calcutta is not functioning through the district magistrate, that is the
Not the principal secretary, not below the
Joint
rank.
secretary, a joint secretary ranked by the principal secretary will be nominated.
Yes, but that for that nomination, they have taken the period for my lord, for 3 months, 6 March 2025.
Correct. It is a vast area. The publication is to be made.
My lord, because my lord, this is a petitioner is a person who is incapacitated, and my lord, 75% incapacitated, my lord. That
what can be done without the
it can be expedite, my lord.
Now the advertisement is on.
advertisement
It
is
will
already
further
made.
delay.
When the advertisement was made, 8th of January.
Right.
8 January.
Why so much? March?
March
2
is
months?
3 months, my lord. It's almost 3 months.
3 months? No, 2 months. February to
Possibly
January,
on the
February.
assumption that the number of applicants are very less. That might be the reason, my lord.
They may come with the, because this is a mere nomination, my lord, they may come with a proposal that the particular person who is acting as a joint secretary under the Department of Health and Family Welfare, Government of West Bengal, and my lord, that person can be.
So now you come to the district judge is already there.
Yes.
Correct.
Yes.
Representative of the district collector, now they have given
Yes,
here.
everybody is there.
Now 2 members.
For members, this advertisement is.
Who shall be the person of mental illness? So this D is to be complied with.
Yes.
D is to be complied with.
Complied with.
So D is to be complied with. They have issued the notification, the publication.
My lord, I don't have any objection other than the, my lord, this is for long.
What can we
He has also come late, my lord. He has come in 2025. I have not.
No, I have not come 2025. This is the second round of litigation, my lord.
No, the correct. So unless and until the member is not appointed, how the board can be constituted?
My lord, this advertisement procedure can be expedited.
No, they have published the notice. Now how the court can? How the court can?
Further complex things, my lord.
No, January is over. January is going to be over. February, March 8th.
Then, my lord, let this matter be appeared on March 7th.
So that is the 6th March. So I am fixing in the 2nd week of March.
My lord. And my lord will direct the secretary to file another report.
Correct. So now the 6th March, the last date of receive of the application.
Right.
Yes.
Correct.
Yes.
So then if they will receive an application, then the process for appointment of the members.
Yes.
So I am fixing in the last week of the March, and I am directing the.
My lord, this is, my lord, on 7th February, I have come before.
That's why I'm telling now that this court cannot go beyond the 6th of March. So what I pray, I will pass an order. So this court will pass an order. Okay, 6th of March is the last date of the application. This court hope and trust that they will appoint the member after receiving the application by 20th of March 2026, and let the matter appear on 24th of March 2026. By that time, the authority also, the special secretary will also nominate the member in terms of the order date.
And, my lord, a mental health review board will be functioning from, my lord.
That's why once the 2 members will be appointed. So already the district judge is there.
Yes.
District judge is there. Now the principal secretary, joint secretary will come. The doctor is already there. Then it
will be coming function, my lord.
That's why. Come on that. In terms of the order passed by this court dated 24th of December 2025, the Principal Secretary, Health and Family Welfare Department had submitted the report dated 9th of January 2026. This enclosing an order dated 9 January 2026, wherein it mentioned that to compromise the Mental Health Review Board in Kolkata area, an officer in the rank of Joint Secretary and above, as may be nominated by the Principal Secretary of the Health and Family Welfare Department, shall be the member of the said. Full stop. In the said report, a paper publication is also enclosed, wherein the West Bengal Mental Health Chairman, West Bengal Mental Health Authorities have published a published a notice calling upon application in the prescribed format for appointment of 2 members in terms of section 74 within bracket small d of the Mental Health Care Act 2017. Full stop. Learned Counsel for the petition submit that the authorities have fixed the last date of receipt of the application on 6th of March 2026, which is far away, which is about more than 2 months, and he prays for shorten the date of receipt of the application so that the matter can be expedited. Full stop. Heard the Learned Counsel for the party. Full stop. Learned Counsel for the state submit that the taking into consideration that application is to be received by the department, accordingly 2 months time has been given for receipt of the application. Consider the submission made by the counsel for the respective parties. This court find that the parties, in terms of the order dated 9th of January 2026, the Principal Secretary of the Health and Family Welfare Department is directed to immediately appoint an officer in the rank of Joint Secretary and above as member in terms of section 74 within bracket B. No, 74 within bracket B of the Mental Health Act 2017.
74 within bracket D.
Yes, 74 B.
B to B.
B. Representative of the district collector.
Yes.
Full stop. This court hope and trust that on receipt of the applications on 6th of March 2026, the Government of West Bengal, Department of Health and Family Welfare shall constitute the committee in terms of section 74 of the Mental Health Care Act on or before 20th March 2026. Let the matter appear on 23rd of March 2024. The Principal Secretary is directed to submit further report on the date fix.
We are grateful. It is my lord's hope and trust that we are doing active things in this matter. Yes, we are grateful.
Because I had dealt with the administration. If we direct, then
Absolutely. Very difficult. There's so much of job also will not assigned to them. Yes. Everything is important.
All the things is to be seen.
We are grateful.
Yes, next. 12 noon.
Item number 30. Just immediately after the file is not here.
Yes.
It appears.
File is not here.
File is not here.
So this is the third occasion.
Why where is the file?
Because we are doing the material also before this honorable court only.
It may be because what has happened earlier, 2 officers, some file is gone here and there. Then they are searching the file. When it will, they are searching the file. It will be, let it be remain in the list. If it is remain in the, let them remain in the list. I am not touching the. Yes, call the list.
Item number 14 is relating to the electricity.
Let the fix. Yes.
Item number 14 relating to electricity matter.
14 to
14. I am 14 and 15. Both are electricity matter.
14 and 15 also.
I am only for 14, my lord.
14 file the. Okay, 14 is electricity matter. You are for the petitioner.
Well, I appear on behalf of
Record an order. 14. The counsel for the petitioner submit that the matter is connected with grant of electric connection. Accordingly, WPA number 13263 of 2025 is released from the list of this court with the liberty to the petitioner to with the liberty to the parties to mention before the appropriate court having determination. Yes.
15 also, my learned friend is
15 is also electricity.
Yes.
Same order. Read petition number. Yes, call the fixed matter.
Please, my lords, my lord, I appear for the petitioner. My lord, may I apprise my lord of the subsequent developments since the last date's hearing? Lordship knows that. Lordship knows that an interim order was passed, and there was a one-time settlement by which we were supposed to make payment of 81 lakhs by 31st December. Lordship had extended the interim order till the 6th of January. Now, the payment could not be made because of reasons which now we'll be putting on supplementary because our buyer backed out at the last moment.
Yes.
Well, at 31st, we were supposed to make the payment. On 30th night, State Bank of India, which was our buyer who was going to make that payment, they backed out. So we couldn't make the payment. When the matter came up on the 6th of January, Lordship, we are left with the option of arguing the matter on merits.
Yes.
Now, Lordship,
But
as
he
I'm
wants
told,
to
my lord, I
back.
was on legs before another.
My lord, that is the main predicament. But my lord, let it be because I am adhering to. So my lord,
May I just
because he was
indicate
not
that-
allowed.
Correct. In my matter, nothing of that sort is there. In the other matter, when that is called, my lord, your lordship would deal with it. In my matter, nobody has gone.
In my contention is, my lord, with regard to the same subject matter, SLP has been filed, caveat has been discharged from
not
our
me.
side. We have already served on the caveators. Now, my lord, that matter, Honorable Supreme Court, is in season of the matter. Now, my lord, this is arising of the same subject matter. The prayers which have been made by them over here, they are wanting certain documents which.
No, Mr. Ganguly or not. State of West Bengal is not being permitted to come.
No, CBI is not allowed. CBI and Union of India is not. My lord, CBI and Union of India is not being allowed to come in. See, because in our petition, we have made CBI a party.
Mr. Dotto is not being permitted to come in.
Well, let CBI be allowed and Union of India also be allowed, Miller. CBI and Union of India is there, Miller, they be allowed.
Second matter, on behalf of respondent number 2, I have with me 2 juniors. Pardon? No, I am that time. We are in a.
It's like that.
On behalf of respondent number 2, I am the senior counsel. Advocate on record is there and assistant advocate. That I am submitting. No.
All organized. Very well. Then may I just proceed with my matter, my lord?
Well, Mr. Raju has been granted access.
While he's there, yes.
Insofar as the ED matter is covered, the ED is the second matter. I believe the prayers before the Supreme Court are almost identical.
My lord, identical. My lord, why? My lord, will kindly bear me for 2 minutes.
He's here.
Yes.
Is there?
Sir,
Yes.
Sir is there, and sir will have address.
Yes. The prayers before the Supreme Court are almost identical.
My lord, identical. My lord, my lord, kindly unmute yourself.
He's here.
Yes.
Is there?
Sir,
Yes.
am I audible? Am I audible, Your Ladyship?
You are. Yes. Before
We have filed
Identical. My lord,
a lot of disturbance, Your Ladyship. May I?
Yes, sir. Please,
We have filed 2 petitions in the Supreme Court.
You are. Yes.
We have filed two matters in the Supreme Court. Being criminal number 16 of 26, 17 of 26, wherein we have made same prayers Maybe we made additional prayers and we have said that the Supreme Court entertains those matters.
Please give me a minute. Please give me a minute. May I?
But it's not audible.
May I
We have made same prayers. Maybe we made additional prayers. We have said somebody is speaking, your leadership, somebody is speaking. I can't.
Sir, can you wait for some time?
Maybe many people have logged in and they have kept their audios open. So that they can be muted from here.
Can you wait for some time?
Many people have logged in and they have kept their audios open. So that
I think mute Mr. Raju.
There is some audio problem from your side.
Mute Mr. Raju. And this is the back effect that is coming. This is the relay that is coming. It was the YouTube because I could hear myself.
Even I could hear
Yes.
something has to be done.
Now it is done, I believe.
May I now speak, your leadership? If
Well,
I'm able-
Mr. Maneka Guruswamy is also there. This is the relay that is coming. She's the lead counsel in my matter. Hear myself.
Even I could hear.
Yes.
Something I do not.
Now
Let
it
me
is done.
hear Mr. Raju.
May I now speak, your leadership?
Everything is being played on Mr. Maneka Guruswamy.
Your leadership, there's a lot of echo.
She's the lead counsel in my matter. Hear myself.
Even I.
Yes.
Something I hear.
Now it is done.
May I now speak? Just everybody else not to speak, your leadership.
Mr. Maneka Guruswamy.
Your leadership, there's a lot of echo.
She's the lead counsel in my matter. Hear myself.
Even I.
Now it is done.
May I now speak? Just everybody else not to speak, your leadership.
Mr. Maneka Guruswamy.
Your leadership, there's a lot of echo.
What we are, because Milord, I was being led by Milord, what our contention is. Yes,
May I only submit this, but may I only submit this, your leadership?
which has been filed by us before the Honorable Supreme Court. What we deals with the same cause of action with the same subject matter. Now, Milord, will kindly subject, my Lord, it is intertwined. It is intertwined to that effect that my Lord has seen our prayer before my Lords.
My Lord, hears me.
Now, my Lord, their prayers are that threefold. One,
Let us see what our prayers is, Mr.
my Lord, may I?
Allow me to at least indicate.
Primarily asking for the.
An adjournment on both the applications.
Why mine? Because I'm not
Why?
the Supreme
Because
Court. I'm
I have been-
caveated.
They are all connected,
I
they're all
always
connected.
have a right to ask for an adjournment because I am a respondent therein.
Please understand.
As a respondent, I have a right.
Let him say.
Now,
then I
my Lord,
submit.
it is for my Lord.
Let me hear Mr. Banerjee. Let me
Correct.
place his case.
My Lord, in that case, my Lord, if that is being done, my Lord will kindly ensure that my leader is made audible and he addresses this honorable court. Because, my Lord, otherwise, my Lord, the person who is I am adhering to, if he is not being able to present the case before my Lord today due to any reason under the sun, then, my Lord, I cannot go handicapped.
Let me place the case.
You can always take your stance after that.
Correct.
Right?
My Lord will kindly, my Lord will, in the meantime, my Lord will ask that let
Oh my God, who's he?
I'm the
Union of India.
Number one.
Yes.
May I only, am I audible now, your leadership? Am I audible?
He'll have the first right.
Sir is audible.
If he's challenging the maintainability, he'll have the first.
Can I just say something that this has become infructuous?
Please.
Effectively. This petition will not survive slowly. Why? I'll tell your lordship because if Dr. Goswami could be added.
No, Mr. Raju is also audible.
What we have asked for and what are our grounds before the Supreme Court context both these petitions. It is not as if it is my petition. I've also said something about the other petition. Supreme Court is said the matter is likely to come up in the Supreme Court within a week. Till the Supreme Court is hearing the matter, heavens are not going to fall. Nothing is going to happen. So let these matters be adjourned.
That is
Your
his
leadership,
submission.
kindly have a look.
But now your lordship would hear my submission.
No, kindly have a look. As far as their petition is concerned, it is mixed with my petition. It can't be segregated. It is not as if the petition can be segregated. Therefore, let this let leadership may hear me. Let both these matters be adjourned to a short date. As soon as the Supreme Court hears the matter, we will proceed with the matter. Even otherwise, on the last occasion, if your ladyship recollects, your ladyship had granted the date. My consent was not that. There are other matters fixed today, important matters fixed today. We are busy also in that. But the main reason why we want an adjournment is that the matter is same petition, same reliefs is before the Supreme Court as far as we are concerned. As far as their petition is concerned, there are some reliefs which are intermingled with their petition. Therefore, this can be kept after some days. If your ladyship may hear both these matters, I'm not running away from that, but only keep it after the Supreme Court is seized of the matter. And even otherwise, when the Supreme Court is seized of these matters, there are judgments to the effect that this court should not hear the matters. Kindly have a look at one judgment, 1986 Supreme Court.
That's settled law, sir.
Then therefore mine is a reasonable request. Nothing is going to happen. And there are so many things that I have to say, even as far as that petition is concerned, but I'm refraining from doing so, even as far as maintainability is concerned, because the matter is pending in the Supreme Court. The judicial decorum requires that till the matter is disposed of by the Supreme Court, this may not be heard. It may be that the Supreme Court may say, all right, go, let the High Court decide. But till that time, the Supreme Court orders have passed, this matter may be adjourned. Your ladyship adjourned it on the earlier date for 3 days. A few more days, nothing is going to happen. Your earlier date, when your ladyship adjourned, they never objected to, they never asked for a hearing. It was me who asked for a hearing.
My lord, I am opposing the prayer of the ED's learned counsel. And if your lordship permit me, I can place my points why I am
You are
opposing.
appearing for?
I am appearing for in the ED's petition for respondent number 2.
I also want to place written submissions on maintainability. Give me time to place written submissions on maintainability. What is the hurry? What is the hurry? There is no interim relief. What is the interim relief as far as the matter is concerned? Now kindly have a look. I'm not on merits. Kindly look at their matter. What is the interim relief
Officer
that they have prayed for?
Swami in the matter. Till the time Dr. Guruswamy is being added, my lord would kindly see.
Who is Dr. Goswami in this matter?
Guruswamy, my lord, my leader. She's the lead counsel from Supreme Court.
Where is he?
She is not being permitted. That is one. And my lord, your lordship would.
Has he got?
Yes, she's done it, my lord. While Dr. Guruswamy is being added, may I just show your lordship page number 16
Of your application?
Yes, of my application.
Now kindly have a look at the interim prayer. Therefore, there is no urgent.
Very unfortunate that I did not interject him.
No, I'm not completed. I've not completed. Then where the question is, you were interjected.
The court to decide whether the court wishes to hear
Good morning, my lady. I'm glad that I was finally allowed to appear.
Now kindly have a look at the interim relief that they've asked for.
And Happy New Year to you, my lady. It's my first appearance in my ladies' court.
Kindly have a
So
look.
I am appearing
Kindly
for
have
the
a-
Trinamool Congress here
Dr.
today.
Meneka, I'm addressing the
In
court.
item 1.
Please,
In item 1.
Now,
Hello,
kindly
Mr.
have a look at
Raju. Nice to see you.
Kindly have a
also.
look at the interim relief that they've asked for, page 20. They've asked that they should not divulge leaking, sharing information of the seized article. Those seized articles are seized by them. No, nothing is seized by the ED. Where's the question of any interim relief?
Merits,
My lady, I was following the
No, it's
proceedings
not on merits. It's
YouTube.
not on merits. What I'm saying
I was
is
surprised to hear
there
Mr.
is no
Raju
interim
arguing
relief which
maintainability on his
requires an
own
urgent
petition.
hearing.
The first time
So
I've heard
why
such
is
an
the matter
argument.
being heard today? When I'm saying that the Supreme Court is seized of the matter.
To make our submissions, I believe.
No, I believe we are entitled to make our submissions, Mr. Raju.
I'm
Now,
not saying that.
my
I'm
lady,
not saying that, but you're
my
entitled to
lady,
make
I am
but the
here.
Submissions are that the matter should be adjourned.
May I just be
until the
allowed to
Supreme
place
decides
my
on the matter.
point? Because I have waited so patiently and eagerly to just be allowed into my
That's
ladies'
not
court.
my problem. That's not
Yes.
my problem.
No, Mr. Raju, of course, nothing is your problem. But be
Yes.
that as it may,
No,
be
no,
that
no.
as it
Then
may,
your ladyship may
my
kindly.
lady,
I have
what
not
is
finished
before my
addressing the court.
lady?
I have not
What is
finished
before my
addressing the court.
lady is
I have not finished addressing the
yes.
court.
Yes, what is before my lady are 2 petitions.
But I have not
I am
finished
here.
addressing. If
I
this
am
is
here
the manner
for
in which the
PMC.
proceedings are being done, then your ladyship may do whatever you want. I am not being allowed to complete my submissions.
Like the petition.
Generally, Mr. Raju, judges are allowed to decide the way they
No,
want.
I'm not saying.
Generally, unless you're
I'm
saying
not saying
something
about the
else that
judges.
we are hearing for the first
Yes,
time
but
today.
you are interjecting and you're objecting and you're intervening when I am addressing the
Yes,
court.
I am the petitioner. Obviously,
yes,
I am the lead petitioner. Obviously, I will want to place my case, Mr. Raju.
No,
Forgive me
said
for
that.
expecting this.
No, no,
Forgive
it's
me
not.
for
It's not a
expecting
question
this. Yes, my lady, may I just say that the petition, the lead petition before you is the one
Your ladyship is not
602
allowing my
of
request.
2026.
You are rejecting my request.
Is
of
rejecting
2026.
my
This is
request.
in the matter of the Trinamool Congress versus the Union of India. Now, in this case, my lady,
I can't hear your ladyship.
our point is
I can't hear your ladyship.
simply this.
Complete, I'll hear you.
Allow. Whenever a mandatory one is being raised, it should be decided first.
Learned counsel has preliminarily said that this has become infractures. That is what he wants to submit.
Allow the person to address the
Absolutely.
court.
So in
My
that
lady, I'm not sure why
Allow
Mr.
the
Raju
person
and
to
the state
complete his
is so
submission.
worried. They have
Allow the person
searched,
to complete
they have
his submission.
stormed. Now they don't want us to argue. They don't want
What
my
is all
lady
this?
to
What is all
hear.
this?
I mean,
What is
you
all
know,
this
it is an
drama-bazi?
extraordinary sign of bullying, in fact, if I
No,
may,
there's no
with
question of
great
bullying.
respect, by the state here.
Yes.
By the ED here, my lady, by the ED, by the Enforcement Directorate. Now, may I
I am
just say
not
this?
running away from arguing the petition.
Yeah,
I'm
may
saying
I
the
just
Supreme
say,
Court says of
please,
the
my
matter,
lady,
let it be
the
exempt
Enforcement
to
Directorate
the
has
matter.
filed something in the Supreme Court. We are not party there. We do not know
Yes,
what they
you're on
filed.
caveat. I'm sorry, you're on
Yeah,
caveat.
Mr.
The copy has
Raju
been
says
served on
that,
you.
oh, it's been filed there, therefore you shouldn't
No,
hear
no,
this.
their
My lady,
copy
we
has
want
been
to
served.
say,
What is this? Copy has been served on them. They're on caveat. How can she argue that we don't know what happened to the
I'm
Supreme
very
Court?
sorry, Mr. Raju, we are not on caveat.
You are on
We
caveat.
are not parties. The Trinamool Congress is not on caveat.
That's the point.
Yes. Now, we are not on caveat. We are not a party. We do not know what the Enforcement Directorate has filed in the Supreme Court. We take Mr. Raju at his word, saying they filed something. Against whom, we don't know. But certainly not us. Now, why I am before my lady, and my lady, it is a privilege for me to be in your court for the first time today. Why I am before is that in this matter, which is the lead matter before you, I want to make 3 points. One, we are not a party in the Supreme Court. We are very happy to be heard by any court. Two, there was a search. Now, all we believe, we are not clear because, you know, the way, the nature of these searches, we don't think anything has been
Well,
seized. If something
if
has
she's
been
claiming
seized, our
ignorance of
privacy
the
may be
petition in the
maintained
Supreme Court, let me
because
please
it is data belonging to a political party. We live in a constitutional democracy. It's a contentious constitutional democracy. We
Well,
are in
I've
opposition.
been
That
mute-
is the way
I've
it is.
been
We
muted.
want our
When I want to
political
speak, I've
data
been
to
muted.
be safeguarded. Many judges in Puttaswamy spent a long time hearing and finding that there is a right to privacy, including on the basis of political ideology. And political data forms a part of political ideology, which is protected by a very large constitutional bench of this country. And it is constitutional jurisprudence and ethos in this country, which is at trial today. That is why I am before my lady. And that is why, Mr. Raju, I wanted to make my point,
No,
if
no.
you will allow me to.
As
So,
far as
Mr.
privacy is
Raju's
concerned,
argument that
it
we
has
are
been
before
dealt
the
with in-
Supreme Court on
the challenge
caveat
was made
is
to Section
factually
70.
wrong. I am saying this as an officer of the court on the record. We are not a party. We are not in caveat. Now, what is before you is a matter which my lady may please hear and dispose of. We only respectfully request as
My
a
lord, somebody is
vibrant and
protecting me.
determined
This is totally
political
unfair.
party that our political data be
Put
protected,
on mute. If
not
this is the way
released,
proceedings
and
are
not
going on, how
released to
can
the
I argue?
media, and not used in a political fashion against us.
Again, I'm put on
This
mute.
is our
Again, I'm
political
being
data.
put on mute.
And in those terms, my lady, we respectfully come to my lady to then dispose of this matter as my lady sees fit. Because unlike Mr. Raju, I don't try to bully courts.
No, I never bully courts.
I
I'm
want
sorry.
to be
Don't
very
impute
clear. So
something
that is
which
why I'm here
unwarranted.
today.
Totally false. How does she say that I'm bullying courts?
India
Where have I bullied the court?
petition, so let me hear him.
No, no.
Very well, my lady.
May only submit, your ladyship may permit me to
Structure
place on record the petitions which have been filed in the Supreme Court. Will the ladyship permit me?
Academic exercise which will happen. Let him speak. Huh? It has.
Banerjee has submitted that it has become.
Let him say.
That's not the submission of Ms. Dr. Goswami at all.
No, I'm saying we are not a party in the Supreme Court. That is what I'm saying.
For preservation of the political
How
data.
does she know? Without seeing my petition, how does she know?
Case status, Mr. Raju, case status.
What
It
case
is all
status?
available online now.
There is no case status. There is no case status.
And we are not on caveat.
Let me hear the Union of India, please.
Yes, please.
Yes.
First
Our
objection
petition may
is,
be disposed in those terms.
I
That
am-
as long as our data is protected, we have been heard. That is all we are asking for.
she is not Union of India. The court wants to hear of Union of India. Who is browbeating the court?
Union of India is here.
Every second my mic is being.
Yes.
Kindly takes the.
Ev- Kindly have a look. Kindly have a look, Your Ladyship.
Sir,
Every second my mic is being muted.
ask you not to intervene. Please, I request you not to intervene. Let me hear the Union of India.
I am also representing the Union of India. I am ED. I am the Additional Solicitor General. Let me make the submissions. I am representing both. My Mr. Banerjee may supplement what I say. But as far as I am concerned, I am the Additional Solicitor General. I have the authority to represent the Union of India.
And what you have said. Let us hear.
Now there is something I have not completed. She has barged in, and every time I want to speak, somebody who has the control of the mic switches off the mic. This is how the proceedings are going on. I'm sorry. It's a very sorry state of affairs. Every second my mic is being unmuted. This is not how the proceedings should go on in a court.
Your Lordship, can you take some of the repetition itself?
Yes.
Again, my mic is muted. I have strong objection. Why is my mic being muted when I'm speaking?
Not muted, sir. But please do.
Your Ladyship will kindly see somebody is playing mischief. Somebody is playing mischief and muting my mic. This can't be done. This should not be allowed. This would amount to interference with the administration of justice. This may amount to contempt.
Our submission is going to the extent of disturbing the court proceedings, sir. I'm really sorry to say
I'm
this.
sorry. I'm not sorry. Let me make my submission. Now I'll make the submissions.
Hear him. He's challenging maintainability. Let me hear him.
He is also my leader, my lord. He is the Additional Solicitor General of India.
Yes.
So far as maintainability point is concerned, my lord, Mr. Raju also may submit all these things.
Mr. Banerjee may submit, then I'll supplement what he says, my lord.
No. He's only on the point that Supreme Court is assessing of the matter.
Is pending,
so the matter may be adjourned. That is his
matter is when the matter is pending with the Honorable
But you
Supreme
are
Court.
challenging maintainability.
I am challenging the maintainability itself, my lord. And my second submission would be, my lord, when the matter is also pending with the Honorable
Maintainability on what issue?
Maintainability on, yes. Kindly take the writ petition itself.
Yes.
But this writ petition was filed by All India Trinamool Congress.
Yes.
Now, my lord, address is 30B Horish Chatterjee Street. My lord, your lordship would get the address, my lord, in the custodial itself. Now, my lord, your lordship, my lord, kindly see paragraph 3. Page 4.
Yes.
The petitioner is filing the instant writ petition is being aggrieved by the colorable exercise of powers by the respondents and for infringement of Article 21 of the Constitution of India 1950 to sabotage the fair process of West Bengal Legislative Assembly election 2026 in the garb of an alleged and purported search and seizure under Section 17 of the Prevention of Money Laundering Act 2002 at the office of IPAC being situated at Godrej Waterside, tower number such and such, West Bengal, as well as flat number 3, Lawton Street, Lawton Mansion, Lawton Street, Kolkata 17. So, my lord, the writ petitioner is basically espousing the cause, my lord, in respect of the search and seizure conducted at different place. The address is different, my lord. Your lordship, my lord, kindly tell the address. So far as these address and the writ petitioner's address is absolutely different. Now, my lord, kindly tell, my lord, next, my lord, paragraph, page 6.
Yes.
Page 6, Lord. After B and C, the last paragraph. It is thus.
Yes.
It is thus apparent the seizure of such documents falling under the above mentioned categories shall have a severe impact upon the conducting the fair election process in ensuing West Bengal Legislative Assembly election 2026, and accordingly such improper and illegal seizure has caused severe prejudice to the petitioner herein. If it is an election process, if we have infected the election process of 2026, ECI has to be made party in this case. Election Commission of India has not been implicated as a party in these proceedings. Now, the entire writ petition is based on 2026 election is yet to be notified. Now, may I just place? The petitioner has not received any notice from the respondent number 2 and 3 under the relevant provisions of the PMLA in the recent times, which entails the respondent number 2 and 3 to seize any relevant and confidential record document data of the petitioner. Relevant newspaper reports, my lord, annexed. Now, my lord, kindly see, my lord, next, paragraph 8. Page 8, paragraph 8.
Yes.
The petitioner states the petitioner has been actively involved in protesting and standing up against the harassment faced by the common man in the state of West Bengal due to the recent implementation of the SIR, a special intensive revision process by the Election Commission. In the said implementation process is marked by mismanagement, capacity, misconduct, and maladministrations, inefficiency, and harassment for the common people of the state of West Bengal. neither the Election Commission nor the central ruling party has any answer to the prolonged suffering caused due to the such implementation. We have recently seen the people of Bihar were also subjected to similar harassment. It is only when the chairperson of the petitioner threatened to knocked on the door of the Honorable Apex Court, the respondent number 2 and 3 have come up with a unique idea of conducting the said search and seizure at the petitioner's political strategies office and its registrar's residence. So, my lord, this writ petition, my lord, basically, my lord, in respect of my lord SIR. Now, my lord, if it is in respect of SIR, my lord, then also, my lord, same thing will come. My lord, Election Commission of India is to be implemented as a party to these proceedings. Now, my lord, let me proceed further. Paragraph 9. Paragraph 9 says, my lord, petitioner further states the respondent number 2 and 3 are known to leak and share the confidential data relating to his investigations to the media and other stakeholders. The same has been widely reported, and such conduct on the respondents has been routinely criticized by the various courts of law. Such history of the respondent number 2 and 3 makes the petitioner even more apprehensive, since the respondent number 2 and 3 is deliberately engaged in a sham search seizure, operating only to gather the sensitive and confidential data of the petitioner. So, the search was conducted at the house of somebody else. The petitioner is coming saying that my data was there in respect of somebody's house. Now, the writ petition can be filed by a person whose right, legal right, fundamental right, or any other right has been infringed. So what is the legal right, what is the fundamental right has been infringed in respect of this writ petition is concerned. Can you see the prayers? Now, prior to that, kindly turn page 10, paragraph 11 once. The petitioner states that the confidential data which have been seized by the respondent number 2 and 3 form an integral part of the right to privacy as guaranteed on Article 21 of the Constitution of India. Moreover, the petitioner, being a recognized political party, being registered under the Representation of People Act 1951, is entitled to enlarge and participate in free and fair campaign and electoral process, which is an integral part of the democracy as guaranteed under Article 19 of the Constitution of India. In the said conspector, it shows that without saying the political parties, much like the petitioners, are commitment on the democratic process, and therefore the conditions must exist where all the political parties, including the petitioners, can carry on its political activities on the just and powerful atmosphere. To halt and impair such democratic process and to restrain the petitioner to participate in the electoral process, the respondent number 2 and 3 have adopted such approach to steal the private and confidential data of the petitioner on the ground of the purported search and seizure procedure, which is partially illegal. Hence, it is a bounden duty of the petitioner to convert the overzealous protect to the right of the petitioner and consequently the protect and preserve such confidential data from being circulated or divulged to any entities at the behest of the respondent number 2 and 3. Now, paragraph 12 says, petitioner states the purported search and seizure operation carried out by the respondent number 2 and 3 is a colorful exercise of statutory power undertaken not for the purpose of justifiable investigations, for the oblique motive assessing and getting control of the confidential and sensitive data relating to the petitioner's electioneer's process. Now, kindly consider the entire writ petition is based on election. The entire writ petition does not say anything about the infringement of any fundamental right. Now, so far as data is concerned, whether I am asking the question to myself, if the data was there at the office of IPAC, if it is seized by somebody while conducting the investigations, how it is connected to the petitioner? Now, kindly see the prayer. Prior to that, kindly see paragraph 14 once.
Yes.
Paragraph 14 says, the petitioner states that there is no proximity or casual nexus between the purported process of crime and the data and document information being seized by the respondent number 2 and 3. As such, the action and overaction on the part of the respondent number 2 and 3 in seizing the private and confidential and sensitive data information documents are expressly illegal. Now, somebody's data has been seized from the house of somebody. He should come forward. Now, in this petition, IPAC, can you see who is the respondent number 4 in this petition? He has been implemented as pro forma respondent.
Yes.
There is no term in law known as pro forma respondent. So he is a respondent. The respondent number 4 should have filed a petition and saying that, look here, the search seizure was conducted at my house. It is absolutely illegal. It is in violation of section 17 or section 50 of the PMLA Act. There is no writ petition has come forward. Respondent number 4 did not file any petition. Now, kindly see the prayer. Kindly turn page 16.
Yes.
Kindly see page 16, prayer B. Prayer A, my lord, I am just a writ of or in the nature, a writ, writs or orders in the nature of mandamus declaring that the action and overaction on the part of the respondent number 2 and 3 to seize and continue to process private, confidential and sensitive data, information, documents of the petitioner and in relation to the operations, affairs, business of the petitioners in the graph of the purported search and seizure operation is banned and illegal. Next, can you see? An order or an a writ or order in the nature of mandamus directing the respondents to return all the articles including but not limited. Yes. But not limited to the private, confidential and sensitive data, information, documents illegally seized in the physical as well as electronic form belonging to the petitioners and or in relation to the operations, affairs, business of the petitioners illegally seized during the alleged search operation. Next, my lord, a writ or a writs in the nature of mandamus directing the respondent authorities to act strictly in accordance with the law and forbear themselves from harassing the petitioners and its main agent assigns in connection with the subject matter investigations and from taking any coercive steps against the petitioner and its main agents assigns on the pretext of ongoing investigation. Writ in the nature, writ or writs in the nature of mandamus declaring that all actions taken by the respondent authorities so far as the petitioner and the private, confidential and sensitive data, information, documents of the petitioner and in relation to the operations, affairs, business of the petitioners illegally seized in physical as well as electronic form are as void and illegal. Writ or writ in the nature of prohibitions restraining the respondent authorities and their mail and agents dealing with and divulging, leaking, sharing informations from the seized article and data informations belonging to the petitioners and in relation to the operations, affairs and business of the petitioners in any manner whatsoever. Next, my lord, prayer G. A writ or writ in the writs in the nature of statutory directing the respondent authorities to produce the entire records pertaining to the subject investigations wherein the aforesaid search and seizure operation has been conducted and the private and confidential sensitive data, information, documents of the petitioners and in relations to the operations, affairs, business of the petitioners that have been illegally seized in physical as well as electronic form before the normal court so that the considerable justice may be done by passing orders as prayed for herein above. Now, we'll kindly see pair J. Interim order restraining the respondent authorities and their main and agents dealing with and divulging, leaking, sharing informations from the seized articles and informations belonging to the petitioners and in relation to the operation, affairs, business of the petitioners in any manner whatsoever. Now, my lord, interim order also asks for in terms of the pairs made in the earlier.
The petitioner is primarily on this prayer.
Yes. Now, my lord, kindly consider.
May I now supplement? Mr. Banerjee, let me supplement now, please. Yes, kindly let me supplement your leadership. May kindly first have a look at two points as far as the maintainability is concerned.
Yes.
The record, if any, which was seized by Mamata Banerjee. Therefore, these prayers of returning of the assets which are seized is not maintainable unless Mamata Banerjee is made a party. Because that is our case, that Mamata Banerjee to physically seized all the record and the digital devices from the premises and she has taken possession of them illegally and committed an offense which petition is pending. Unless Mamata Banerjee is made a party who is in possession of illegal possession of these articles, these prayers and this writ petition is not maintainable. So in the absence of Mamata Banerjee being made a party and in the absence of the DG of police and the police commissioner who have abetted the offense, if these prayers can't be granted because no record has been seized by the ED, all records have been seized illegally by Mamata Banerjee and her cohorts. Therefore, the first thing is this is not maintainable because Mamata Banerjee and the persons who have seized are not made parties. Secondly, kindly have a look at the affidavit at page 23.
Yes.
This petition is filed by a person who has no knowledge, who is a stranger, nothing. Now kindly look at the person who has filed the affidavit at page 23.
He has been
I, Subhashish Chakravarti, son of late P.P. Chakravarti, aged 68 years by faith, Hindu by occupation, self-employed and residing at 39 MG Road, so-and-so, Calcutta, 7000822, hereby solemnly affirm and says as follows, that I am the authorized signatory of the petitioner. Kindly look at who is the petitioner. I'll come back herein. That I am well acquainted with the facts and circumstances of the case As such, I am competent to sign and affirm the affidavit. How does he become acquainted? He was not there at the search. He was nothing to do with the search. Now kindly have a look at the cause title and I'll show who is the petitioner is Trinamool Congress. Kindly have a look at page 1 of the petition. The petitioner is All India Trinamool Congress. So he is an authorized. Come back to page 23.
Yes.
He is an authorized signatory of the petitioner. Where is that authority? There is no authority produced along with the petition. That is the authorized signatory. And now further, how does he become well acquainted with the facts? Was he present when the seizure took place? Was he present when the search was taking place? Was he present in the so-called material was seized? No, he was not present. It's nobody's case. It's not even his case in the petition. I'll take your honor, ladyship to that petition. I'll come to that a little later. Now he says, the statements contained in paragraphs 1 to 9, 17 and 19 are true to my knowledge. False statement on oath. He is supposed to be taken forward. He was not present anywhere. And rest are my respectful humble submission. Now kindly have a look at paras 1 to 9 of the petition. I will read the petition to show he was nowhere in the picture. He could not have filed this petition.
Yes.
Now kindly have a look after the points of law are concerned. Para 1. Petitioner is a recognized political party, namely All India Trinamool Congress. This is page 3 I am reading. Your ladyship has got it?
Yes.
Petitioner is a recognized political party, namely All India Trinamool Congress, AITC, formed under Section 29A of the Representation of People's Act, represented by Mr. Subhashish Chakravarti being its authorized representative. The petitioner is currently in power in the state of West Bengal pursuant to a landslide victory in the West Bengal Legislative Assembly election 2021. Having defeated all the other rival political parties, including the Bharatiya Janata Party, petitioner is contesting the ensuing West Bengal Legislative Assembly elections 2026 by fielding candidates in all 294 assembly constituencies in the state of West Bengal. The petitioner has its office at the address mentioned here. The respondent numbers 1 to 3 are the state within the meaning of Article 12 of the Constitution of India, and as such are amenable to the writ jurisdiction of this honorable court. Respondent numbers 2 and 3 are commonly known as Enforcement Directorate, which is responsible for conducting investigations under the PMLA.
Getting to point out, sir.
No, because I'm showing that he has made a false affidavit of what he has said, does not disclose that he has knowledge about the search and search, therefore false affidavit. Therefore, I have to read these paragraphs. Para 3. The petitioner is filing this instant writ petition being agreed by the colorable exercise of powers by the respondents and the infringement of Article 21. He said, this is true to my knowledge. This is true to his knowledge. Fair procedure of West Bengal Legislative Assembly 20 in the garb of all alleged and purported search and seizure under Section 17 of Prevention of Malundering. The fact that Section 17 powers, what powers they have, are pending. This is pending before the Supreme Court in the matter of tax back. That also I'll point out. This very issue about the scope and power of Section 17, which is there, is challenged before the Supreme Court, is pending. Therefore, Supreme Court is seized with this matter on Section 17. Now, your ladyship may kindly have a look, referred to as PMLA, at the office of IPAC being situated Godrej Water site so-and-so, as well as flat number 3 so-and-so. So it is at some other place, as my colleague Mr. Banerjee has pointed out, nothing to do with Trinamool Congress. And the person whose premises are seized has not come before your honor and complained about the seizure. Kindly note this. Petitioner states that the Indian Political Action Committee, IPAC, is a professional political consulting organization, provides strategic research communication on ground of campaign to support political parties leaders across India. In the process, the group helps them set a citizen-centric agenda, partners with leaders to conceptualize and implement the most effective methods of taking it to the public and gathering mass support. IPAC has been associated with the petitioner for approximately 6 years, providing end-to-end 360 degrees campaign support.
Sir, not the entire writ petition. I have
No,
gone
I'm saying, because he said paras 1 to 9, I'm showing that this doesn't show anything about his...
the entire writ petition.
Now, I'm not reading the entire, I'm saying, showing the paragraphs, which is paragraphs 1 to 9 is what he refers in the affidavit. He says, this is true to my knowledge. Now, kindly have a look. How does he get the knowledge? How is he concerned? Not a whisper in the entire petition. Now, kindly have a look at a judgment of this Honorable Court, which is binding to your ladyship. CRM SB 53 of 22. My colleague must be giving a copy to your ladyship.
Yes.
The judgment.
Sir is referring to.
Apex Marine Services LLC versus State of West Bengal.
Actually, you are practicing, that's why.
It's not us.
There's a break now. I can respond now.
Till my learned friend gets a printout, my lord, may I proceed further, my lord?
Sir, I'm just
Now,
giving a copy.
You've given a copy to the Honorable Court?
So you kindly refer the judgment. I'll give the copy here and now.
The judgment is CRM SB 53 of 2022.
Sir.
In application and in the matter of Apex Marine Services LLC.
Is that the citation, sir? Citation would be
It
useful.
is unreported judgment. Versus State of West Bengal.
I'm saying. It is for everybody. It is unreported order in CRM SB 53 of 2022, dated 19/4/2022, in the matter of Apex Marine Service LLC and Prabhu Shipping Lines Private Limited versus State of West Bengal. I'm handing over a copy to Mr. Banerjee on my tab. Please, I'm getting the printout. Please accommodate.
LD 53.
Sir, you may proceed.
Now, kindly have a look at, I'm reading from the second page, second paragraph. I'll read from second. At the outset, Mr. Ayan Bhattacharya, learned advocate of respondent number 2 has raised a technical objection. He takes me to page 22 of the application for cancellation of bail. Page 22 of the said application contains affidavit sworn by the constituted attorney of the complainant petitioner. In para 2 of the affidavit, the deponent has made the following affirmation, that the statements made in para 1 to 30 are information derived from the record, which I verify and believe to be true, and rest are my humble submission before this Honorable Court. It is submitted to Bhattacharya, learned counsel for the respondent, that the application contains 31 paragraphs, out of which paragraphs 1 to 30 are stated to be information derived by the deponent from the records. Mr. Bhattacharya then refers to various paragraphs of the application. That is why I was referring to those paragraphs, not because I wanted to delay the proceedings, because the affidavit contains that it is to my knowledge, paragraphs 1 to 9. Mr. Bhattacharya then refers to various paragraphs of the application, submit that statements made by the petition in the application for cancellation of bail cannot be said to be a matter of record, as the application is not informed. Mr. Bhattacharya prays that outright rejection of the same. In support of the contention, he refers to Rule 27 and 28 of Chapter 4 of the Appellate Side Rules. The above mentioned rules are quoted below. 27. When the declarant in any affidavit speaks of any fact within his knowledge, he shall do so directly and positive using the words I affirm and say. When the particular fact is not within the declarant's own knowledge, but is stated from information obtained from others, the declarant shall use the expression I am informed, and if such be the case, should add and verify believed to be true. So nothing is from his knowledge. His derived information, and this portion of Rule 28 is violated. And he must also state the source from which he received such information. When the statement rests on facts disclosed in documents or copies of documents procured from any court of justice or other source, the deponent shall state what is the source from which they are procured and its information or belief as to the truth of the fact disclosed in such documents. Copies of documents other than those on record of the case to which it is in.
Supplementary affidavit. The petitioner was allowed to cure the defect by filing a supplementary affidavit. The writ petition was
I
not.
have not received it. I have to be given, therefore let it be adjourned. I have to have a look at the copy of the affidavit. If it does it behind my back,
In this matter, the petitioner was directed to file a supplementary affidavit.
I'm not aware of this. This is coming for the first time to my knowledge. Your ladyship, I must know what is the affidavit that he has filed.
No, sir, Honorable Court is referring to the judgment which you are citing. Factual
Yes, I'm sorry. Judgment, yes. That was, I'm sorry. Yeah, I'm sorry. My ladyship is referring, yes. Therefore, let me read 28. I'll complete the judgment. I'm so sorry. I'm so sorry, your ladyship.
Please come to the concluding part.
I'm just let me read this, please. when the particular fact is not within the Rule 28, when the particular fact is not within the declarant's own knowledge, but stated from information obtained from others, the declarant shall use the expression "I am informed," and if such be the case, should add and verify, believe it to be true. And he must also state the source from which he received such information. When the statement rests on facts disclosed in documents or copies of documents procured from any court of justice or other source, the deponent shall state what is the source from which they were procured, and his information or belief as to the truth of the facts disclosed in such documents. Copies of documents other than those on record of the case to which it is intended that reference should be made at the time of hearing shall be annexed to the affidavit and is marked as exhibit. As an exhibit shall bear the certificate of the commissioner before whom the affidavit is made. It is further submitted by Mr. Banerjee that in view of the provisions contained in Article 215 of the Constitution of India, the High Court is a court of record. Therefore, defective application cannot be retained in the record, and such application should be rejected. And further refers to a decision of the Constitution Bench of the Supreme Court in State of Bombay versus so-and-so. Paragraph 16 of said decision is relevant. We wish to, however, observe that the verification of affidavit produced here is defective. The body of the affidavit discloses certain matters are known to the secretary who made the affidavit personally. Verifying, however, states that everything was true to the best of the information belief. We pointed out this slipshod verification of the type might well be given in a case lead to rejection of the affidavit. Verification should variably model in the lines of Order 19, Rule 3 of the CPC, whether code applies in terms or not. And then in subsequent case in L.R. Shivama Ramagowda and others versus T.M. Chandrasekhar by and LRs and others reported in 1999, 1 SCC 666 at page 672, the Honorable Supreme Court made the same observation. Mr. Imtiaz, learned advocate for the petitioner, does not dispute that the affidavit was wrongly affirmed by the deponent. He prayed the liberty to file a supplementary affidavit to rectify the error. Now, your ladyship is right. Here, there is no such prayer. Now, I'll take to your ladyship what is the implication of this affidavit. I'll come to that. Situation as to whether the application will outright to be rejected for the error or defect of the affidavit is dealt with by the court in so-and-so, reported in so-and-so. It is observed that the court, while considering rule so-and-so affirmation not made as per rules 27 is curable defect and is granted to remove the said defect in the affidavit before the commissioner by filing supplementary affidavit. Then, in view of the above decision of this court interpreting rules 27 and 20 of chapter 4 of the appellate side, the court is of the considered view that no fruitful purpose served with the application and about technical ground, the defect may be cured and directed opponent to supplement the affidavit in accordance with the appellate side rules. It has to be cured. Therefore, before entertaining this application, the defect has to be cured. I'll tell you, ladyship, why in the present case the defect can't be cured, because the defect goes to the root of the matter. It is a false affidavit leading to perjury, which would entail filing of an application under 340 of the CRPC. Now, kindly have a look at the petition again. The petitioner is not concerned, not the petitioner, the person who has filed the affidavit is not concerned, not present at the places of search. The places of search are at